Good afternoon, all.
Good afternoon.
We're resuming the afternoon session of the Commission of Inquiry, and it's my understanding that we have a rather preeminent attorney who's going to enlighten us as to some banking practices, and leave it to you, Counsel, to make a formal introduction.
Thank you, Chairman, Commissioners. I'd like to call the next witness to give evidence, Mr. Christopher Swann. He will give evidence in relation to bank practices, regards to recovery of monies owed under mortgages, possession of land thereunder, and he has a wealth of experience, but I won't speak on his behalf. He's more than capable to speak. I just ask that the witness is either sworn or he is allowed to affirm, depending on his conviction, religious or otherwise, if the Bible could be given to him, or he may affirm.
I swear on the Bible. Thank you.
Sure. You just...
I, Christopher Swann,
I swear by Almighty God
swear by Almighty God
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Good afternoon, sir.
Good afternoon, and good afternoon to the commissioners and the chair and council.
Afternoon, Counsel. Now, sir, you are a barrister and an attorney at law.
Yes,
How long have you been practicing?
20 years call this year.
Thank you. Where do you practice presently?
I'm the proprietor of Christopher E. Swann & Co., 26 Church Street, Hamilton.
Now, are you licensed to practice anywhere else?
No.
Now, I'd like to speak a little about your 20 years at the bar and even before. Prior to being called to the bar, do you have any expertise as regards debt collections?
I have many years of expertise in debt collection. Before I even went to law school, I was working with Julian Hall, who members of the commission will recognize the name, in his law offices, Hall and Associates, and under that umbrella, a collection company called JS Management was doing debt collection, and I worked closely with them and their practices, probably for, I think, 5 or 6 years before even going to law school.
Thank you. And those were debt collection in relation to what type of matters?
Contractual debts, for the most part. They involved everything from enforcement of promissory notes. There were 1 or 2 mortgage recoveries during that time period. Other contractual debts for service providers, telephone companies, and the like, including landlord and tenant matters as well.
Thank you. Now, since being called to the bar, you have dealt with debt collection matters and property law-related matters.
Yes, in fact, since being called to the bar, and in some respects, during a period of pupillage and maybe for a year or so before that, I had involvement's a better word, in conveyancing matters representing vendors and purchasers, from the sale and purchase agreements to the drafting of conveyances, to the drafting of security documents, mortgages, further charges. Mods were a new phenomenon, so back then we weren't doing as many of those. Financing for corporate entities. We also incorporated limited liability companies. General other areas of law, but the debt collection involvement, debt collection sort of practice became more involved, I'll put it that way, in that there was more time, particularly once being called, in court, usually in the lower courts every Wednesday and Friday. In fact, those are the new dates. They used to be, I want to say, Tuesdays and Fridays in the old court building for enforcement of collection and enforcement of debts. And after being called, Supreme Court chambers characteristically on a Thursday for the same debt collection matters. As the practice grew, we were involved with, I'll say, every bank that loaned money, every lending bank on the island, in terms of assisting with the drafting of mortgages. Our recovery work, mortgages and finance documents, our recovery work was more limited to two of the, I'll call them the three banks. But we probably did over the course of the years anywhere from dozens of cases representing either the banks trying to collect monies that were defaulted on in regards to loans and mortgages, and conversely the same amount of clients perhaps defending those particular claims, not including just general advice, which would be on both sides, to banks and to clients.
Now, specific to the debt collection and your appearance in the magistrate's court, you mentioned probably twice per week in the days of old, probably Mondays and Wednesdays. How long did you do that for?
Since I've been called, that's every week.
20 years.
That's easily 20 years. Prior to that, when I was just prior to my leaving Bermuda to go to law school, I started going to court. I would be sent just on the collection matter, so I would add another 5 years to that.
Okay. And in respect of at the Supreme Court?
Supreme Court was definitely after call, so that would be limited to 20 years.
20 years. Now, with regard to the expertise regarding mortgages and loans, is that a practice that has evolved with the Supreme Court practice, or there was that at the magistrate level?
Enforcement of mortgages and loans is a Supreme Court matter. So in terms of experience, that would be limited, appearances would be limited to the 20 years. I had involvement on files prior to that, but not in terms of advocacy in the Supreme Court.
Now, finally, as regards the banking practices and especially enforcement of mortgages, you would consider that you consider yourself to have had or to have a wealth of experience?
I would say that I do have a wealth of experience.
Chairman, in respect of the evidence of the witness, Mr. Swann, he has outlined over the last 20 years his experience since being called to the bar, appearing in the magistrate's court, the Supreme Court. He also gave evidence in respect of, prior to being called to the bar, experience he had for some 5 to 6 years as it relates to debt collection, and specifically with regard to the expertise regarding loans and mortgages, generally for the, I would say, for the 25 to 26 years. It is my submission and application that he be considered an expert to speak on the matter of banking practices, the enforcement of mortgages, or other forms of security to secure a debt and to be allowed to give evidence to the Commission of Inquiry?
Yes, counsel. As you were speaking to the witness, it came to mind that for the purposes of this Commission of Inquiry, that Mr. Christopher Swann be considered and deemed to be an expert. And that will be placed on the record.
Thank you very much. Now, Mr. Swann, a request was made by the Commission of Inquiry to you to provide an opinion and to appear before the Commission of Inquiry.
Yes.
And the opinion that you have prepared and that which was requested of you, could you share with us what exactly was the subject area that you're asked to provide this opinion on?
Well, I will read to you actually the first paragraph of that, which sets out.
And just before you read it, are you able to tell us what is in the paragraph without reference to the document?
It's an opinion on banking practices in regards to delinquencies on loans, the enforcement procedures and practices that are used, what court orders are made and require in terms of sale, and particularly whether after sale there is equity that it would be returned to the borrower. The opinion touches on practices and procedures as I have experienced. For the most part, the process of initiating the action, what I have perceived as the usual defenses that are raised by borrowers or defendants, and I interchange that word throughout the opinions, and I give an overview of what, from my perspective, the reality is on the ground for most of these matters.
Okay. Would you wish to refresh your memory from the document?
I may from time to time. I think in terms of your question, it says that this opinion is intended in general terms to include banking practices, to enforce mortgages or other forms of security, to secure debt when the debt becomes delinquent, and in particular, what if any court order is required for sale and whether on any sale any remaining equity is returned to the borrower. So I think I've, in broader terms, explained that that was the purpose of.
Okay.
And with your leave, of course, there may be times when I would like to refer to what I've said.
Okay. And certainly, it's easier for you to refer to it than to try to recall it through memory.
Fair enough.
Okay. The opinion that you have prepared for us is it's 11 pages and 42 paragraphs.
Okay. I had printed out a copy for myself, which seems to differ from that slightly. It's 42 paragraphs, but my pages are 13 or 14, but I'm assuming that's just based on the size of the print, and
Yeah.
but I'm quite sure it's the same.
It's 42 paragraphs.
Yes.
Mr. Chairman, I'd ask that the opinion of witness, Expert Mr. Christopher Swann, 42 paragraphs, and I just ask him to sign his copy now so I could say of today's date. After he I crave your indulgence. Could I just ask you to sign the copy you have? I just ask, Mr. Chairman, that the opinion of the witness, expert, Mr. Christopher Swann, comprises of 42 paragraphs that could be tendered and admitted as Exhibit CS1.
Yes, the opinion of the witness Christopher Swann, barrister, on banking practices in Bermuda, composed of 42 paragraphs, be indexed as Exhibit ES1.
CS.
Say it again.
C as in Christopher, S as in Swan, CS.
CS, yes, C. My correction.
Thank you.
And just as a sort of further comment, this opinion, as you know, will certainly be used, considering your expressed opinion, as a criteria for assessing certain banking matters that will come before the Commission going forward.
Oh, thank you.
Thank you. Now, Mr. Swann, could you just indicate to us the background and the basis of the advice, please?
The background, quite frankly, is my personal experience. Again, from dealings with the banks in regards to recovering monies on their behalf, also defending persons who found themselves defendants to banks' actions. And that was not only from an advocacy point of view, from appearing in court or dealing with claims that had been filed, but also from advising both parties in regards to scenarios that had arisen over 20 years of practice. That's the background, and then the basis, quite simply, was the instruction or request that was put to me by former counsel.
Thank you very much. Now, could I take you to paragraph 2 of your opinion, just to get some context of the...
Let me indicate that I believe, embarrassingly so, you've just been sent an incomplete or former version. I'm just looking at it. One of the, paragraph 2 should say classically banks loan. And this says classically, it says something else.
Well, I think what appears on the screen is accurate.
Okay. What I've been given and signed is not. So I will ask if I could be provided with that copy. But so yes, I'm back where I need to be. Classically, banks loan monies on the security. Yes.
Thank you. Crave indulgence. Okay. What I'm being advised is...
What I can do, if it assists, is quite simply when this is concluded, I'll be happy to sign this document or any of the other documents that are correct.
Correct.
But I can proceed on the basis of what I have in front of me.
Please, because what you have in front of you is what has been projected on the screen.
Yes.
So please proceed.
So I'm going to...
I want to take it to paragraph 2 and to give some context within which the security of first legal mortgages or any other type of agreement is established.
The highest form of security that the banks have, or that is in place, is a first legal mortgage. It is a conveyance of title and property to the bank in exchange for money. It's really that simple. I think everyone, and anyone that's ever been in that position knows that the bank gives them the money, they agree to pay the money off, and once the money's paid off, the property is transferred back or reconveyed to them. So that would be the highest security that a bank has. Second to that would be a Memorandum of Deposit of Deeds, which was known as a MOD. Now these were, in my view, documents, they've always existed, but they had some prominence, I would say, in the 80s and 90s, where they were used, in my view, by the banks as a means of securing loans for existing customers of good standing. So instead of taking someone who had the resources and monies to easily pay off a mortgage and whatnot, and already had a banking relationship with the particular banks, instead of having them execute a full legal mortgage, they would have them execute a mod. And the difference is that a Memorandum of Deposit of Deeds does not affect a transfer of title in the property to the bank. What it creates is an equitable charge. It creates a lien or lien, depending on how you want to pronounce it, on the property in exchange for the money. Now, the opinion does go on to talk about the language that's used in most of the Memorandum of Deposits of Deeds for the banks, and some of the language just varies slightly, but one of the things you generally see is an undertaking or a promise by the person borrowing the money that should the bank request it, they will execute a first legal mortgage over the properties in exchange for the monies that at that stage would have already been lent. There are instances where banks will loan monies, loan monies just by way of loan, forgive me. Those you classically tend to see where the person has cash assets in the bank and simply wants a loan secured by those cash assets, even if they're going to use that money to purchase property for the sake of this discussion. Promissory notes are very rare because they are what I would consider the lowest form of security that the banks would give. There is no collateralization generally in them. Even if the promissory note mentions the purpose of the borrowing and then that land is involved, it still doesn't affect a transfer or a lien. And in order to get to that stage, proceedings would have to be issued and judgments obtained and the like. This paragraph goes on to talk about a combination of these securities associated with single loans. I have seen instances where banks have loaned money secured by mortgage and shored up that lending with, it wouldn't be a mod because that really wouldn't make sense in the sense that you already have a mortgage, but with promissory notes or personal guarantees. You tended to see more of that pre-1990, or say 1995, mid-90s, when you had scenarios where people borrowed money secured by mortgage, but you had persons who were not on title that guaranteed the borrowing. You also tended to see a multiplicity of different documents with company financing. So if a company borrowed the money to purchase land, if it had the ability to do so under the Companies Act, you would see a mortgage, maybe even a debenture, personal guarantees, and promissory notes. So sometimes you do have combinations of all of those documents. But again, the highest form of security were your first legal mortgages. If that assists.
And you have made a distinction between what happened in the 1980s and what happened in the 1990s. What is typical today?
Typical today, you do not see, I think I can say that with certainty, you do not see situations nowadays where people will guarantee mortgages as a separate, you'll see separate guarantees. Banks insist that persons are on title to the particular properties involved. So you don't see guarantees anymore as independent documents. You don't see as many, in fact, to be fair, I don't think you see memorandum of deposits of deeds, or at least I haven't seen them come across my desk, so to speak, since turn of the century, 2000 or thereabouts. I think the general thrust is that the banks would prefer to have the highest possible security to protect their position, as opposed to the practices of past, which by today's standards would probably be considered loose or looser than they are now. Let's put it that way.
Thank you. Could we go to paragraph 3?
Yes. Is there a question? Would you like for me to just to take you?
Take me to it, and I'll leave it to the question after.
Okay. All right, we're at paragraph 3.
Now, in paragraph 3, you spoke generally, well, in your introduction, and I refer specifically to the penultimate and the final line in paragraph 3, in terms of what the general idea is, in simple terms, of a borrower and the relation between the borrower and the bank. This is a typical scenario that is represented in paragraph 3. Is that correct?
Yes.
That
upon repayment of a mortgage, the property is reconveyed, transferred back to the borrower. Now, I will say that you do have, on occasion, instances where the transfer is to the borrower and others, but the banks, the thrust of this is that the banks will transfer the property back. In fact, as a matter of law, they must transfer the property back once the mortgage has been repaid.
Now, you're aware, I'm certain, especially based on your expertise, that there has been some concern, especially in Bermuda, regarding the practices of banks and the perceived, whether real or whether perceived or actual, in terms of person losing property. You're familiar with that
Yes.
sentiment?
Yes.
And certainly I can alert you that the presentation, the questions to you may go in that direction very shortly. Now, let's talk a little bit about the Memorandum of Deposit of Deeds, because I know you mentioned, you refer to it in paragraph 4, but I know you mentioned that today's day it is not something that is utilized much. But
Yes, we don't see it as much at all, if at all.
Right.
And I think perhaps it's of note that, in my view, that, and I think this may be shared by some people that have had experience with seeing these documents, it was more of a convenience that the bank provided for their valued clients that were borrowing money. Instead of making them go through the expense, and it's another point, in fact, the stamp duty on a first legal mortgage is calculated in bands. 1/4 of 1% for amounts under $400,000 and 1/2 of 1% for amounts above. And I believe memorandums of deposit of deeds are 1/10 of 1% across the board. So it was less expensive in terms of the stamp duty. But again, it was more of a convenience. And I think that just based on probably international practice and amongst other things, they've done away with that. We definitely see correspondence from banks nowadays indicating that the loan or whatever the facility was has been paid off. That was secured by memorandum of deposit of deeds, and execute the appropriate release or instructions to that effect. But we definitely don't receive instructions nowadays to draft up memorandums of deposit of deeds, and haven't done so for some years.
Okay. And not only did you, I think importantly, based on your earlier evidence, the banks have well, call it international best practice now to seek to have the strongest, is my very unforensic word if there is such, to have the strongest type of arrangement with a borrower.
Yes.
And that is the strongest, to hold on to something in case there's a default.
Yeah, the first legal mortgage definitely is the strongest security here.
Now, there is not just a view, but a fact that the recovery of debt after the default of a borrower has created much angst in Bermuda. There is a perception, real or a perception, that there are unfair practices that have been undertaken, and there's a complaint from borrowers that financial institutions have engaged in unfair practices to the borrower's detriment. I would like us to speak a little before of that, but before we get into those questions, I certainly would like us to give some context to the general atmosphere, the environment, and to speak a little about banking based on your expertise. Now, the law as regarding mortgages, as regarding loans, it is governed by Bermudan law and the English common law, correct?
Correct.
Okay. Now, I'd like to take you to the second page of your opinion. Craven. I was just trying to ascertain whether or not the projection of the presentation precluded viewers from seeing the witness, but I'm assured that they are not seeing the presentation, but they are hearing and seeing the witness. I was just trying to ascertain that fact. My apologies. Now, let's speak a little bit about mortgage companies or financial institutions seeking to recover debt from borrowers. I'd like to speak a little about that. Could you just guide us in terms of how these matters originate, how they are commenced, initiated?
I touch on this somewhat in paragraph 5. When I say proceedings to recover debt are akin to a summary judgment hearing. To explain that, I'm sure counsel would appreciate this, what a summary judgment hearing is. There are provisions in our rules of the Supreme Court. Lawyers often call it Order 14 proceedings, and that is where a claim has been made against someone, and the defense or defendant raises a defense that really is not a defense to the action. It has no weight, and you can apply by summary judgment proceedings under Order 14 for judgment based on affidavit evidence because there is not a defense or a viable defense to the claim. So when I make reference in this matter to akin to a summary judgment hearing, the reference, quite frankly, is that when banks issue proceedings, they are based on usually a simple premise, and that is there is a default on the payment of interest and principal, or an amortized payment of both. And there usually is, quite frankly, no defense to that payment having been made, in the sense that the defendant will say, well, yes, okay, I accept that I'm in arrears. And they may give reasons for why, but the simple fact that they are in arrears of the contractually agreed mortgage repayment is enough for a court to be moved to consider that, okay, the claim being made must be given, go back a step or go forward a step. The plaintiff that is suing should be given judgment on the basis that the defendant really has admitted that which they are complaining of. Mortgage recovery actions are usually commenced by originating summons, which is one of the 4 ways that you bring a matter into court. But originating summonses are supported by an affidavit, and that affidavit, deposed on behalf of the bank, will set out, amongst other things, the contractual relationship that a mortgage existed as of whatever the date was between the bank and the defendant or defendants, the people that borrowed the money. It may also list any guarantees or guarantors if it's of that older vintage. But it will discuss the amount borrowed, what the payments were, the interest rate, and then will condescend into the default, or what the bank claims are the arrears. Based on that, that will be served on the defendant or the defendants, and then they will, usually they'll have 2 weeks or thereabouts to, originating summonses will set a date for an appearance, and at that first appearance, normally what will happen is that the courts will give them an amount of time, usually 2 weeks or thereabouts, to reply to by way of affidavit, to the affidavit evidence that's presented. And in that reply, if there are matters that are raised which put into place a defense to that action, and the matter will be set down for hearing. That's for originating summonses. For matters that are commenced by writ of summons, now there are 2 types. You either have a generally endorsed writ of summons or a specially endorsed writ of summons. Generally endorsed writs of summons have a brief summary, particulars of claim, of what the claim is about. It may say, this is a mortgage recovery action. between whatever the bank is and whoever the defendants are for X amount of money. What happens in those actions is that is served on the defendant or defendants, who would then have 2 weeks to file what's known as a Memorandum of Appearance. That is a document just indicating that they are defending the matter. In the actually, a document setting out the address of the either lawyer that's defending them or their address for service, and it indicates that they're taking steps to enter an appearance. They've received the writ and they acknowledge it. Let's put it that way. They would have 2 weeks after that to file a defense to the claim, and then the matter can go in several different directions. If there's no valid claim, then again, I mentioned summary judgment proceedings could take place after that. If there are, for monies that are claimed, if there is an application for possession, which can be made under various sections of the rules of the Supreme Court, the matter could be set down for a hearing in front of a judge, even in the Thursday chambers list, which I had mentioned in the very beginning, for the matter to be adjudicated, or it could go to a full-blown trial. You usually see generally endorsed writs of summonses or specially endorsed writs of summonses for collection of monies that are secured under memorandum deposits of deeds. You definitely see them as the means of initiating actions for monies that are in default on loans and promissory notes. That's generally the starting process.
Now, also in a general sense, whether a customer of a financial institution or somebody who wants to become a customer, he identifies a property, whether commercial or something that is residential, and he goes to the financial institution and he asks to borrow money. So that was just in simple terms for the layman, what really is that mortgage? So somebody decides to acquire something. What is, let's speak a little bit about that.
Our friends, the real estate agents, are usually involved in this sort of scenario, in the sense that property is for sale, person express an interest, they get past the offer and acceptance part of the purchase. And what usually takes place is that a sale and purchase agreement is entered into between the vendor and the purchaser. And that sale and purchase agreement will set out all of the salient details about the property, its location, its size, by way of written legal description. Attached to the back of it will be a site plan, usually outlined in red for the actual property, with yellow showing easements and rights of way, and other colors for other things. And it'll have terms in it. Some terms even include financing. I'm saying all that to say that usually in that scenario, the person has gone to the bank and said, right, I'm interested in buying this property. Can you assist me with financing it? And the banks will ask for the sale and purchase agreement because it has all of the relevant details, including the purchase price, the deposit, etc. What would then happen is that the bank will instruct a valuer to go out and value the property. And that is so that, well, I don't want to say it's obvious, but that is so that the banks can be sure of the value of the property in terms of not only what they can lend based on the value of that property as security, but what the flowing from that, what the borrower can pay in terms of their liquidity. Now, that doesn't all come from the property value, but you have to start at that in order to start the ball rolling in terms of what the bank's prepared to lend, and then the liquidity is more supported by the person's proof of income from their employer or from their business and the like. And the bank takes the value. They will loan. The percentages have varied over the years. You used to have scenarios, so I won't go back as far as what some people might say the heyday, because that may depend on your respective ages, but banks at some stages were loaning or offering to loan or provide, 100% financing based on the value. And in those scenarios, they would oftentimes, that's actually a good example of where they would have other security documents outside of the mortgage. There'd be loans and promissory notes and perhaps collateral mortgages on other properties, but they'd give you 100% of the value of the property. In more recent times, banks usually hover anywhere from 60 to sometimes 75% of the value of the property, but it's always been an underlining theory, or practice is a better word, that usually the person buying the property had to at least come up with 10% of the value, which was the deposit that was paid on the sale and purchase agreement. And beyond that, the banks would provide financing up to a percentage. And that's basically how those scenarios developed. Now, in terms of the bank's internal workings, I often would tell clients I don't speak bank. There are things sometimes that banks will, because of their own procedures, and particularly nowadays with the absolute increase in regulations for AML and ATF and all sorts of other things, some of the internal procedures that the banks have to undertake are not what they used to be. I think that's the best way of expressing it.
Okay.
But in general terms, the person pitches up to the bank and says, this is what I want, and they support it with either that sale and purchase agreement, or if it's not a case of a person buying the property for the sake of the argument, let's say you already own the property, or you've had it bequeathed to you after a family member has died, and you go to the bank for money to renovate, you'd still require the valuation, or the banks, forgive me, would still require the valuation, so they could enable them to know what type of security or how much security they would have in terms of the loan. It's important to note that in some respects, this way of dealing with mortgage relationships isn't particularly endemic to Bermuda, but it is not the norm worldwide. In the UK, for example, the mortgage or the providing of a mortgage is more income-based as opposed to property value-based. The banks are more concerned with your longevity of employment and how much you make, as opposed to the fact that the leasehold that you're buying or the freehold that you're buying is worth a particular amount of money, so that in default they can sell it. Whereas in Bermuda, the opposite is, I'd say, more prevalent. The desire is to have as much security based on the value of the property, as opposed to initially the income. That's the secondary consideration. And even examples of that include, much to the dismay, I suppose, of a lot of borrowers, they'll have a property that's worth whatever the value is. Let's say it's $500,000, but that property will have 3 apartments, and those apartments are easily let's say $10,000 a month for the sake of the argument. The banks will take that rental income and lessen it, or they'll take a percentage proportion off of it for the guarded scenario that the apartments aren't always rented for the sake of the argument, and still base most of the decisions on the financing on the value. So I'm just making that point, that it's more geared towards that as opposed to the income that it either generates in most scenarios or your income working. They're concerned about that secondarily, but I hope that addresses.
It does, and I'm not asking a question, but I make a comment. I think in some instances, they also take out life insurance policies, the value of the property, so if anything happens, the security, well, you are their security.
You don't see that universally. You do see it in some scenarios. In fact, it's not, in my experience, to be fair, it occurs, but it may not be as prevalent as people think. It's not the norm.
In another place and time, I'll tell you about that one. But I'd just like to take you to paragraph 9 on page 2, and importantly, based on the context and the general framework that you have been establishing, the idea of someone who is borrowing, someone who has borrowed, and you did indicate how proceedings are initiated or commenced in a court, we have a scenario that presents itself that someone defaults.
Yeah.
And having defaulted, there is a process now to recover. And that process to recover, especially in an instance where there is some collateral, it creates much angst in terms of the perception, or whether it is in fact real, that there are the method to recover the debt is a little unfair. I'd like to take us a little in that direction.
One of the things I did not mention, in all fairness, and it just rang to mind, is that I said proceedings commence. Court proceedings commence in the methods that I have already mentioned, but the actual collection proceedings always, should always, but to my experience, always commence with letters before action. And I using that term because a demand, I think, comes after the letter before action. The letter before action basically is a letter saying you're in arrears, please regularize your arrears to avoid further action. Normally, by the time these matters go to collection, the banks, I would think in most circumstances, I mean high most, 90 to 95% of the time, they have written or attempted to write to the borrowers at least for over a period of 3 to 6 months. In fact, in fairness, it's usually considerably longer than that. But I have seen scenarios where 6 months and they're filing writs. The rationale sort of behind that, is that there is banks will not usually start to pursue legal action until 3 months worth of interest or 3 months worth of the amortized payments have been missed. So in the first instance, you usually you'll default, and you'll get a phone call, and the bank will say, well, you're in default, please pay this. At least with the banks that I've worked more closely with, I generally tend to hear that they will make phone calls, or even the people that I've advised, they'll say, yeah, the bank called us. So then they will call, then they'll write, and once, if that does not bear any fruit, then you'll have the demand, which will say that your mortgage is so far in arrears, here's the amount, unless this is cleared up within 30 days, or whatever the case may be, then we will be issuing proceedings. In terms of the unfairness, I think it's very important to remember, or to consider, let's put it that way, that for the majority of people who find themselves at the defendants in mortgage recovery actions, those actions are very, very emotional. I touch on that later on. This is, the homestead or the house that was purchased years ago at a very high value, and mortgage payments were made consistently, and then all of a sudden the job's been lost, or the value's gone down, or something's taken place, and they're unable, the mortgagor, the borrower, is unable to make the payments. And out of that scenario, there will always be emotion attached. And I think for the most part, there will generally be a feeling that they are being treated unfairly. Now, in terms of particulars of that unfair treatment, the biggest complaint that I seem to have experienced is that late fees and charges. So it's not bad enough that you can't make the regular monthly payment, but as soon as you miss the monthly payment, you have late fees, then you have interest, unpaid interest on the regular payment. And it begs the old question that if you couldn't pay $1,000 now, how can you pay $1,500 the next month?
Right. And
going forward. And that of course, strongly lends itself to the view that the recovery actions are unfair or unjust. On the same point, one of the things that is contained in the mortgage documents, for most mortgage documents, at least the older ones, were provisions for costs to be recovered by the attorneys, and basically, without necessarily using the word indemnity, words like full cost or any cost incurred. So the attorneys will bill the bank for the work that they provide, and that's passed back on to the person that's the borrower or the defendant. And oftentimes those aren't particularized when matters come to court. It's different from, let's say, a debt collection matter for an unpaid phone bill, just picking on phone companies unnecessarily, and the bill is $100. The new debt collection legislation from 2008 sets out that as a matter of law now, you can add 20% to that bill. Same argument applies. We couldn't pay $100, well, how can you now pay $120? But the distinction I'm making is that at least you know by the time you get the letter before action that your bill is now $120, and particularly you know when you go to court that that's the amount. You don't see that as much, or in fact you don't see that at all, quite frankly, in mortgage recovery actions, because the attorneys will bill the bank directly, and after the matter is substantially settled, particularly after judgments are awarded or the matters are concluded, they can file what's known as a bill of costs. And that bill of costs can be taxed if it's not agreed, which is the normal language, and those monies will be monies that sort of present themselves, the quantification of those monies usually present themselves somewhat after the fact. You never see them at the beginning of the action. So you may very well, and I touch on this with some of the common defenses, is that the monies are wrong. The amount the banks are claiming are never really reconciled at the first instance with the person that owed them because of the fees and charges and whatnot. But one of the aspects of unfairness definitely is the expenses that the banks will incur.
One of the complaints.
One of the complaints, excuse me, the banks will incur.
And just before you go there, if I may, there's this view, real and perceived, that especially when the matters reach some procedural proceedings before a court, we have passed the 3 months or any period, whether 6 months, where letters of demand have been written and there has been no answer, or the answer and the payment has been insufficient, that persons believe, and I'll say it as simply as I can, that the reason why the approach is being taken is because the bank has a big lawyer and I am the person who is a borrower, I don't. And there is that belief that we are unequally yoked, and because of that there is that Samson and Goliath situation. Can you speak a little on that?
Well, one of the things mentioned in the opinion is that there are three, or express a view that there are three important things to consider when you are involved in litigation with a bank. And that, number one, they have very good legal teams. This is in-house. And their loan documents have been drafted by qualified experts, and they have endured not only the test of time, but they evolve with new laws, legislations, and practices. So they're very good at making sure that the documents that set out the legal relationship are very good documents. Secondly, and I think I express it as a corollary to the first point I've just made, is that banks are very good at keeping written records of just about everything, which means that they have very good paper trails which can be used to support their claims. And then thirdly, banks have very deep pockets. And with very deep pockets, you can afford to hire the best of the best to represent your claims. And usually when you are paying very good money to attorneys to provide for you a specific result, they are in high gear trying to make sure that they can do that. And with those, with those considerations in mind, you do have David and Goliath in most circumstances. And I would say the majority of people that find themselves through unfortunate circumstances in default don't have the business savvy to address the matters themselves. And because they are, quite frankly, if they're in default of the mortgage and other things, do not have the resources to hire the same caliber of attorneys, or attorneys at all, to represent their claims. So yes, there is, from that point of view, an element of unfairness. But I should flip the coin just a little bit. If I go back to my comments to the previous question, one of the principles that every attorney learns when they're doing contract law, which is mortgages are contracts and loans are contracts, is that damages in contract are assessed to put the innocent party in the position they would be in had the contract been performed. So the underlining principle or argument that any bank can make is that, well, we had a contract whereby I loaned you certain amounts of money. You agreed that you would repay those monies by equally amortized monthly payments of interest and principal over a certain course of time. If you default on that, then I should be, in law, put in the position I would be in had you not defaulted. And that opens up, in some instances, very wide scenarios where, well, I had to go hire an attorney, and this is what the attorney costs. And I could go down various different roads, but I thought it was important to at least put that out there in terms of the last answer, because it is in law the rationale and the rationale for why there may be these other fees and charges and expenses. Because a bank can always say, well, you know what, in default, and you see this on mortgage instruction letters, there will be penalty or interest of X in default, as opposed to the normal interest, which is Y. So you do see that. But the reason that is enforceable is just basic contract law in terms of damages and the fact that the person borrowing the money has agreed to it. So that doesn't take away from the perception that it's unfair by any stretch of the imagination, but there is a legal rationale, I think, that the banks will quite happily employ to explain that. And I think that is the basis of that explanation.
Thank you, and I certainly will ensure that my next example speaks about David and not Samson when we refer to Goliath. Now, I'd just like you to take us to some of the, based on your experience, what are some of the defenses that are advanced by borrowers in respect of a bank who seeks now, the bank or financial institutions seek to demand?
All right, I set these out, and I touched on the first one that's particularized, and that is that the banks provided an inaccurate or misleading picture of events. And by that, I mean that events leading up to the actual claim, and most oftentimes it deals with the quantum of what is owed. And sometimes it's not necessarily the lack of provision of the quantum, it's the details of how that quantum is arrived at. Because and I think the reason, and this is just my view, the reason is that when you are in default of a mortgage, the bank has the spreadsheet and the computer program that says, you know, Mr. Smith will pay $3,012.50 every month. And he doesn't pay that $3,012. And when that doesn't happen, debt protocol kicks in, and it'll add whatever the penalty interest is on top of the regular interest, which accrues every month. And then it'll add the late fee and all that. So instead of after month one, where it's $3,012.50, month two turns out to be $3,240. But there's no particularization of that when it comes to there isn't sufficient all the time. It's particularization of that when it comes to the court proceedings. So that's the first thing. Secondly, we found a lot of people complaining that, well, I sat down with the bank and we negotiated that I couldn't make the monthly payment the way it was, so I could pay interest only. And they allowed me to do this for a particular period of time and the like. But the general defense was that discussions took place and we entered into an agreement, and now the bank are breaching that agreement. The problem is that oftentimes there are agreements and concessions that are made, and they're usually time limited. And once that time period is up, it's almost like a respite. Well, instead of paying the $3,000, you can pay the interest, which is, you know, $1,000, well, whatever the interest is, for 6 months or a year. And you pay it, and then after that, it goes back to what it was. And there's sometimes misunderstanding of the actual agreement that's in place, and that it may be subject to the higher-ups, meaning some greater authority than the loan officer who's just simply speaking to you. And there tends to be a lot of, I'd say, confusion in that regard. Thirdly, the banks exercise some form of coercion, undue influence in regards to...
Perceived.
Perceived, forgive me, yes, alleged or perceived. Or threats in an attempt to have the property sold or to take the person's property that's mortgaged. We see it not as often, but sort of as a first cousin of that the banks have intermeddled with the borrower's property, the appointment of receivers, efforts to sell. Because you do see on many occasions where the person is in default and they, throw their arms up and they say, right, I will sell this property. And they'll go off and make private efforts to do so. In some instances, even engaging real estate agents to sell it. And then you'll have someone from the bank indicate that they've found a purchaser and it may not be at the same value and the like. Because sometimes they are, I think what's misunderstood is that there are occasions where the banks are being proactive in the sense that the loan officers know of people that are buying properties and the like. And if something comes across their table that's in default, people have conversations. Well, number one, Pleasant Street is the owners that are in trouble, or number one, Pleasant Street might be foreclosed on. Well, gee, what's the price? Well, and this is where it gets a bit murky, and I'm not saying this is what takes place, but there's a perception that this takes place.
That ethics become involved.
And ethics become involved. And in fact, I'll leave it at that level. Conversations take place, and all of a sudden there's a buyer who miraculously made an offer that's dangerously close to the amount that's owing on the mortgage, as opposed to arguably what might be the value of the property, which might exceed the amount owed. So we've had that come across our desk a few times. And that sometimes relationships of trust and confidence have been breached by the bank. So I've characterized those as broadly the sort of areas that we tend to see in terms of defending the bank's claims.
Okay. Now, in terms of that run-up of a short length, what's your general view regarding the indebtedness which arises, the actions which may be initiated, the defense which are oftentimes advanced by borrowers? Have you arrived at a general view? And I'll take you to it at paragraph 13.
Yes, I mean, in reference to your first comment, generally short pitch deliveries go on the back foot and dispatch them properly to the boundary, but from my evening league experience. In fact, it's probably good to read it. I mean, most defendants to mortgage recovery actions have an emotional connection with defending what is usually their family home, and defenses to the actions, whilst in some instances are persuasive or compelling, as a general proposition, it has to be borne in mind that proceeding with litigation which is unmeritorious is far from sensible, and in particular will lead to the borrowers having to incur legal costs and expenses that the borrowers have to pay in terms of the bank's expenses and bank's costs. I say that to say that the inability to pay your monthly mortgage payment is not a defense that can be employed in court. Life happens.
But it can be employed, it just may be summarily dismissed.
There you go. We tend to find, I mean, there are, let me be clear. There are defenses that have been successful in regards to bank actions. I'm not saying that, well, you know what, the bank sues you, that's it. Just make plans to move and get on with something else in life. What I'm saying is that I think that people need to be very careful, because there is an emotional attachment in most instances to their properties, that going down the road of simply wanting, because of emotional reasons, to save the property is not a wise course of action. And in all fairness, because of some of the things that I have mentioned earlier on, the fact that the banks have usually very good legal departments. Their documents have been time tested. They're good documents. They keep accurate and very good records usually of matters that take place, and they have deep pockets. If you find yourself on the wrong end, if a person finds themselves on the defending a mortgage recovery action, and the reality is that they just don't have the ability to make their payments, the advice is to see if you can settle the matter on the best possible terms you can with the bank. And that encourages, hopefully the result will, those actions will result in a few things. Namely, you won't be going to court and incurring the bank's fees in terms of their legal expenses, because as soon as they go to court, even if you're trying to, if they go to court, they're going to be expenses, you're going to end up paying for it in most circumstances. And secondly, if you can settle the matter amicably, and I mean by settlement, if refinance in some instances is an option, go from one, we've seen people go from one bank to another successfully. And refinancing might not only be moving banks, it might also be changing a 10-year facility to a 20-year facility, which may necessitate, particularly if the borrower is older in age, if they're agreeable to it, adding children and the like to the title to help make the payments and whatnot. The general thrust of that is if you can resolve the matter in most of the circumstances based on, from my experience, the fact that at the end of the day, the bank is going to have a judgment of some sort, then the advice usually is to see if you can settle it. And that also adds to this is unfair. It's a perception that matters are unfair.
Now, I know, especially today, you hold no brief for any financial institution or any bank, but there is this perception or view that whether it is a settlement, whether a borrower says to a financial institution, I have a third party who is willing to purchase. Let's speak a little bit about the bank or the financial institution's obligation to accede to the request of a borrower to go in a particular direction, or the bank's obligation to do as their banking rules and regulations stipulate.
Well, let me be sort of very, very clear. I am speaking from my experience, and there may be of late in particular banking policies and procedures which have taken effect, but particularly nowadays to do with COVID and the financial problems that a lot of people have incurred. Now, so what I don't want to do is sit here and advocate that the banks have these particular policies that they must follow, because those policies in a lot of instances are moving targets. And those aren't necessarily things that are divulged in terms of, the bank is now doing A, B, C, D, and E. I can say as a matter of law, if you deal with contract, there is a principle in law that a person claiming damages must mitigate their damages. They must do things that do not cause them to suffer more damages if they can particularly prevent that from happening. That's just a general proposition. If you put that into the context of your question, there is no obligation at all on a bank to invite, for the sake of the argument, Mr. Smith to come in and inquire, do you have younger members of your family that you can add to this title who can take on part of the responsibility of paying this mortgage because you are in arrears? I think that what takes place is that the banks will put various scenarios to persons, to qualified persons, to see if they can be of assistance. Now, remember, to be sure, banks are in the business of making money. And I tell clients, almost every time I have a client in front of me to execute a mortgage, I will say to them, I'd like you to remember, banks are in this to make money. The bank does not want your property They really don't. They're not real estate agents or real estate brokers. They want your money. And I think the incentive would be in situations where they can fix a scenario, very wide term I'm using, not very eloquent, but if they can fix a scenario, they will do that, because ultimately that means that they will continue to receive their money. And not only the principal that they've loaned, but interest, which anyone that's ever had a mortgage knows. At the end of a 20-year mortgage for $1 million, for the sake of the number, you have paid an astronomical amount of interest. Doesn't matter what bank you're at. It's a big number. And if the bank can maintain that, that's in their best interest. So we have had, to my experience, many of scenarios where the person that's had the mortgage, who's paid on it, 10-year mortgage, it's 10 years into it, a 20-year mortgage, 10 years into it, find themselves in difficulty. The children are now out of school, employed, and they're like, right, I can extend this by another 10 years. The bank has said so, as long as I put someone younger on, because my working life, as far as the bank is concerned, they're 60 years old, and the bank will cut off or not extend in usual circumstances beyond 65 a person's working life. So those are usually I think those are the most common fixes that we tend to see. The secondary sort of fixes we tend to see, and banks will suggest this, I think, quite readily, is if there is other collateral that can be used to collateralize the loan. So you're in arrears, you're not making the payments, but if you can offer the bank the assurance that there's other collateral around, it might seem like a bit of it may raise questions. Well, if you're not making the payment, what's the use of more collateral? You can still stretch the loan out. You can extend the term. And that also may involve other people. So the answer to the question is that I don't think the banks are necessarily obligated by any stretch of the imagination to recreate the wheel to assist anyone with trying to regularize their relationship, but they do have a vested interest in trying to mitigate their losses, and also because, to try to see that the income stream from that particular transaction is maintained. Because if the alternative happens, and that is, let's just say you have full foreclosure proceedings and you have to sell the property, the banks will still be in a position, and if we take today's present climate in terms of real estate values, for a foreclosure of a property that a mortgage was entered into, let's say 10 or 15 years ago, you've borrowed, that property value has not, in most instances, appreciated. In fact, it's depreciated, and you'll have negative equity scenarios that may present themselves. So all of these things are necessarily, or should be necessarily taken in, I believe they are taken into consideration when decisions are made in terms of the question that you asked.
Thank you. I'd like to take you to paragraph 16, and in terms of your opinion, regarding the hope and expectation.
Most, I think that it is, it just sort of goes part and parcel with the emotional part that emotional aspect of these proceedings, that people who find themselves in a scenario where they really do not want their house sold will sometimes employ or try to employ any method they can to delay the bank's action. And quite frankly, it's with the hope that a buyer will come along, or that they have made application, for example, to refinance with another bank, but that takes some considerable time these days. And so they're basically buying time. I tend to find that is more of a reality than not, because there is hope that the matter will be resolved one way or the other. Also, I was involved in a particular matter with the former Chief Justice, who actually raised the issue that in a lot of, in quite a few cases, the courts take the approach that in situations where there is some issue that's raised, which may not be the best defense or a very strong or viable defense, and it's shown to be that, but there's still some thrust involved in either trying to negotiate the matter, or in fact, if they are trying to see if they can secure financing. The courts have taken an approach in several matters I've dealt with of making an order, granting judgment for the amount that's claimed, and making an order for possession for the banks, but delaying that order for a period of 3 months. So they'll make the order today and they'll say, right, it takes effect 3 months hence. And that gives the parties the chance to see if there's any last-ditch effort that can be used to remedy the situation, whether that's by sale or otherwise. So in terms of that comment, it's supported by, somewhat supported by some practices, court practices in some of these matters.
I think we could summarize so far to say a man's homestead is his castle. I'd like to take us to paragraph 17. You have, by way of summary, sought to summarize what we have done so far. Could I direct you to the fourth line of paragraph 17?
Sorry, let me look at yours. The bank's position that monies are, the sentence starting the defendant's inability to pay? Or the next sentence?
I'm sorry, I think because of the different, it's paragraph 1, but the fourth, nor do claims, yes, the fourth.
Nor do claims of dropping property values and gender. What we have seen in the last, since the last recession, let's just say that, is that people that have been involved in these actions have said, you know what, I don't have the ability to pay. And I think that there is in some cases, an obstinance almost that presents itself. I've paid this for the last 10 years, and now, because of my circumstances, I just cannot pay. Surely someone must be able to understand and accept that and cut me some slack. And whilst that engenders sympathy and empathy and understanding,
Or ought to.
and it ought to, a defendant's inability to pay is not a defense to the bank's position that monies are owed. That sentence speaks for itself. We've also heard, and we've seen this recently since the last recession, that the property value of this, or the value of this property when I mortgaged it was X, was $1 million. I'll keep picking on the $1 million number. And it's now worth $750,000. Surely the banks must want to recognize that and take some sort of action accordingly. And it is, in terms of sort of critical thinking classes and the like, it's an appeal to pity, which is also understandable. But it still doesn't get around the fact that when that property was bought, the amount of monies that were borrowed. And that is just a fact. And whilst, like I said, it should engender some form of sympathy and understanding, in terms of the contract itself, it does not provide a remedy in law to say that the terms of that contract should change. Now, there are actions that the banks have taken recently, and we will all remember when the COVID-19 crisis was at its full had its full effect on Bermuda in terms of the shutdown. The various banks, and I think they all followed one another, but there was mortgage payment relief in that if you were a customer in good standing, you could basically communicate with the bank and say, look, can you waive the mortgage payment for the next month, or I think it was 3 months, if memory serves me correctly. And some of the scenarios involved waiving altogether, but the interest clock would still run, and you would catch up later on. But there was some forbearance, I'll use that term, in regards to the bank's behavior or actions, actions in that regard. But in terms of a lot of the claims that we've seen that involved people asserting that the property values had dropped, which they had, and that they couldn't make the payments, there is not a legal requirement that the banks amend or change the particulars of the contract to reflect that.
I smile because of you give 3 months, but in some other places it's 6 because of COVID, and interest runs, and then the recalculation occurs at the very end. No, but moving on, that's not why we're here, my point. I would like to take you to the defenses that are oftentimes advanced by borrowers, and in some circles, some borrowers will speak to fine print that they never really read or they didn't know existed, or in this instance, the initial agreements or the agreements discussions, the negotiations that led to the lending of money and the securing of something of value which one likely will lose. Let's speak a little about that.
We've tend to have found that the stronger defenses, if we're compartmentalizing them under agreement, are those defenses that assert that the original agreement was not, or there were defects with the original agreement, or lack of understanding, or I touch on it later on, that independent legal advice wasn't required or provided in some of the scenarios. Those are much stronger arguable issues than what we were seeing a lot of, which was the negotiations post-demand. In other words, they get to the demand's been made and proceedings have been issued, and then we would have in the defendant's affidavits allegations that they had spoken to the loan officer, who agreed that as long as they made some payments per month, even though they weren't the prescribed payment, then the bank would exercise some degree of forbearance. And I discussed that later on, saying that the difficulty is that most often these agreements, whilst acted on, aren't necessarily acted on conclusively, in the sense that the payments are always made and it's always a set amount, or they were always subject to some form of approval from or sign off from the bank, which never occurred, but the bank were quite happy to have them in place. This is the complaint. The bank were quite happy to have them in place, and then notwithstanding, they've, forgive the expression, pulled the plug. Those arguments aren't as strong, as I've said, as the argument saying that there was something wrong with the original entering into the contract and by the particular parties. But you don't, and that again, I use the word vintage, depends to a large extent on the vintage of the transaction, because you will find nowadays that there is an absolute requirement by most of the banks to have sign-off indicating that the parties to a loan transaction, particularly if there are persons that are providing collateral mortgages by way of other properties and the like, that they have taken independent legal advice, and even scenarios that involve matriarch or patriarch of a family adding a child onto title, and the child is borrowing the money based on that property to renovate it or to go buy something else, that the matriarch or patriarch, as I refer to them as, has taken independent legal advice. And it's not just an oral confirmation. They want something in writing signed off by the attorney. So nowadays, that whilst you have seen recently, in fact, if my memory serves me correctly, we had one case this year involving a property that's located not too far from here, and the person had guaranteed...
This year, 2021.
2020, no, sorry, I beg your pardon, 2020.
Okay.
In a property that's located not too far from the regiment, where the Supreme Court, or the court ruled that there were, I'll just very badly paraphrase this, there were problems with the initial agreement, and that there was a requirement, there should have been a requirement for independent legal advice and the like, and as a result, there were people that were, I'll use the vernacular, on the hook for this particular borrowing that had some, a remedy, some reprieve. So it's not as if it doesn't exist, but I think, quite frankly, it was based on the vintage of that particular matter, because nowadays, after quite a few cases, some cases is a better way of putting it, in Bermuda on this particular point, I think the banks have amended their practices such that these scenarios are much more difficult to find themselves appearing nowadays and in the future, or will find themselves more difficult to appear. So that's sort of agreement. I can move on to...
Please.
Quantum mentioned this. It was the first of the defenses, so I apologize, it seems to be back to front, but the complaint that's usually made is that, you know, I owe $3,000 a month for my mortgage payment. I am 1 year in arrears on my mortgage payment, therefore I should owe $36,000, 3 times 12. And you find out that that $36,000 isn't in fact $36,000. It's, you know, I'm making this number up. It is...
I'm sorry.
It's the next one, if you keep going. Go to paragraph 21.
Sorry.
Sorry. It's, instead of using my scenario, if the payment is $3,000 a month and you're a year in arrears, you would expect to receive, or the person expects to be, to receive a claim for $36,000, 3 times 12. What they don't. They receive a claim for, you know, $42,000 or some greater amount of money. And it's the difference between what is perceived to the defendant or the borrower's mind that they know they owe, and what is being claimed, which we mentioned earlier will include late fees, late penalty interest, I'll call it what it is. On some occasions, you usually don't see the legal fees at that stage because, quite frankly, they're not quantified, and it's a moving target, so to speak. But the amount that, to the mind of the borrower, should be easily set out isn't. And this more often than not, the person throws their hands up and says, well, you know, I don't owe $42,000. I know that for a fact. But you know what? I owe 36. It does not, let's put this another way. It doesn't help with the perception that treatment is unfair, because it's not necessarily rubbing salt into an already wound based on the emotion of the contextual, the emotional context of the scenario. It's more a matter of, well, if you tell me I owe 42, I know I don't owe 42, and there's a belief that on that basis it'll sort of all go away. And that compounds the emotional part of it and the feeling that there's been some form of injustice. But again, the simple fact that, and oftentimes raising the issue will force, if there are deficiencies in the pleadings, will force the pleadings to be amended such that they are particularized so that every penny is accounted for, just call it what it is. But it's not a defense to the action and that the action will be dismissed, because there's usually always an admission that some amount is owed. It's just that we don't agree with the amount that's presented. The next
Interference.
topic is interference. You don't, I say in the first part of that there is interference by the bank in property transactions with a customer could be said to constitute a tort. And I make reference, to a case of OBG Limited in Allen. It's a 2007 case, and the tort consists of a person using unlawful means with the object and effect of causing damage to another. The burden of establishing that is the interference or the existence of the tort is on the borrower or the defendant. Now, again, if we're talking about David and Goliath, you have a person in most, or persons in most circumstances that find themselves in these positions that might not have the resources or means to instruct attorneys to represent them when they think that there has been some interference by the bank with the property. Not only is it, in most circumstances, something that would involve detailed instructions and advice in regards to the interference, which necessarily means that it's going to cost you some money with the attorney. But it's not the easiest of torts to establish, bearing in mind that from the day that the mortgage is signed, that property was conveyed over to the bank. So if the bank sees in their ultimate wisdom, and I would theorize that if the bank sees in their ultimate wisdom that, you know, you're a year and a bit in arrears, and some person presents themselves that can not only purchase the property and clear off the existing debt and all manner of other things, it would clearly be an avenue that I think any reasonable person, if they weren't dealing with a bank or bank dealing with this scenario, would at least investigate. And those investigations, I think, in most instances, constitute the basis of claims for what I've called interference.
I'd like to take you then to paragraph 26, because there are some views also in the realm of perception.
I think that 26 touches on, greatly addresses, let's put it, addresses the emotional part of all of this. And one of the issues with Bermuda is that we are a small community. And to use our vernacular, everybody knows everybody's business. And if you, and it's not uncommon that, you know, you find, or people find themselves in a position where they're in arrears with their mortgage. And they will quite happily know that, I seem to be picking on John Smith and Joe Smith today, that John Smith is also in arrears of his mortgage. He owes more money than I do. Well, how come the bank aren't going after him? You tend to have scenarios of that nature that develop in small communities. They're endemic to small communities. If we were in some large city in the UK or in the United States, that sort of knowledge would be something that would be obtained by happenstance. It's a circumstance here that you tend to find people will complain because they happen to know, and I will put on this level as a matter of fact, that they're being chased and someone else isn't. That's in a similar position. And that, for obvious reasons, does not go down well when you're dealing with people who may believe that they are being treated unfairly.
Nor does it take away from the fact that you actually do owe money.
Correct.
Okay.
Correct. It doesn't take away from that. And you can, pick your poison on this. We've had scenarios that have been presented to us that I think are easier to understand than others. That's a better way of putting it. Where you have someone that's considered by other people, let's say, to be wealthy, that has a variety of different assets, properties, and the like, who, and you see this, who may have developed a property for the sake of the argument, and owes lots of money to the bank in terms of that development. But you have John Smith again, who borrowed...
Tom Strokes.
Sorry?
Or Tom Strokes.
Oh, Tom Strokes, who borrowed very small amounts of money and is being pursued, whereas this other person whose financial net worth, let's put it that way, may be significantly higher, isn't. And when I say understandable, there may be scenarios involved where that person has a dozen different properties that they could sell to satisfy the debt. And so therefore the bank might be a little patient or more patient in exercising their rights, as opposed to the person with the one property who doesn't have the means to raise the money as opposed to the other. So, and that, again, doesn't help. And the other thing that's touched on, the other matter that's touched on in that particular paragraph is that, again, because we are so small, everybody here is related to somebody, is everybody else somewhere along the line. You know, it's your cousin that's the loan officer, or I'm being pursued by Jill Smith, who's, you know, who I'm not related to, but I know for a fact that she's not pursuing her cousin, Gary Smith, who I know is in the same position I'm in. We're a small community. That happens. It doesn't help. But it doesn't get away from the fact that the bank any plaintiff, any person that's in a contract that sues, that is a plaintiff that has been aggrieved because that contract has been breached, can sue or not sue. That's the bank's choice. And there is nothing, there is no mechanism that can be employed by someone to say, you know, why me and why not someone else. It is absolutely the bank's choice. And I think I'd go on further in saying that, in fact, I go back to the end of that paragraph, that sentence. If the bank are entitled to bring proceedings by virtue of the mortgage's guarantees, it seems plain that the mere fact that a loan officer or bank employee charged to collect the outstanding debt may have a personal animus or dislike for the borrower will not assist, that's the borrower, in defending the claim, nor is the fact that the bank have treated other customers or borrowers differently. That's a matter for them. And it does go on to talk about the a legitimate threat, which may induce a borrower to enter some contract or arrangement. It might give rise to a claim for setting aside of such a transaction as being a form of economic duress. But part and parcel, the interference, for the most part, I don't know personally of any successful examples of economic duress being visited upon defendants in any cases. So I will say as a blanket, usually the interference arguments, which are based on the bias or animus, are usually not successful.
And one may reduce them to anecdotal.
Correct, absolutely, yes. Trust and confidence. I would say that some of the successful defenses to banks' claims have been founded in the breach of trust and confidence. More so because there seems to be a tie-in with the argument that we didn't take independent legal advice, or it wasn't offered or required. I didn't understand the transaction because I trusted the bank. And I trusted the bank officer. They've never led me wrong in the 50 years I've been doing this. Why did it happen on this occasion? And it does, as a corollary, flow into those cases that have been successful for the most part, that deal with not giving independent advice and the like. And there's, but I've left that one sort of as it is. And again, I go on to, when I say I've left it as it is, it deals with negligence, which is a particular species of law. And whilst I haven't delved extensively into the negligence sort of argument or tort, but negligence involves there being a duty. And arguably in this case, it would be the banks have a duty, and that duty could be to properly, use the word advise very guardedly, properly advise people that are getting into mortgages to take independent legal advice, or to, because a bank's function isn't to give financial advice. But there would be a duty in negligence. There must be a breach of that duty by the bank. The breach of that duty is the cause, in fact, because the bank has breached their duty, in fact, I'm now in the position I'm in. It therefore would be the reason in law that the defendants in the position are in, and that the damages that flow from that breach must not be too remote. In our circumstance, the damages would be the inability to pay, or the lack of understanding that an obligation was there to pay. So whilst I didn't condescend to that level through those paragraphs, that's the basic snapshot of negligence, and why on some occasions those claims of breach of trust and confidence have some degree of success.
So some persons, Mr. Swann, who are borrowers who have been taken before the courts. They unfortunately seek to rubbish the principle of contractual estoppel.
Yes.
And they think that it is something oftentimes that has no place and ought not to be relied on, especially by a plaintiff. Could you just touch on that for me, please?
Estoppel is a principle in law, try to put it, boil it down to its lowest common denominators. If you have relied, in essence, if you have relied on a promise or this instance a set of circumstances, you can now not go back after relying on them and say that the circumstances did not exist. And this is, or that you didn't rely on them. In terms of the banking relationship, contractual estoppel arises, the non-reliance on it appears because it's hard to argue that at the time of entering into the mortgage, you did not realize that you were borrowing the money. This is the property that was securing the loan. Your monthly repayments were whatever they were, that the term was whatever it was. Those circumstances that existed in that contract between yourself and the bank existed. And you cannot, after the fact, particularly years down the road, say, well, oh, wait a minute, they didn't exist. They were in writing. They existed because of the actions, the simple fact that the property was mortgaged. It's been registered. You've made the payments. It is extraordinary 2 years later or sometime after the contract has been formed to go back and say, well, hold up, I'm not really sure what the facts were. And for that reason, contractual estoppel, as it's referred to, is employed or can be employed. One of the specific reference to being used by plaintiffs, estoppel is a area of law that falls under, or a principle law that falls under what's known as equity. It is the law of conscience, if you want to phrase it that. It may not be enshrined in statute or enshrined in basic contractual principles, but there are some instances where equity steps in, the law of conscience. It is unconscionable for this to take place, and therefore we will prevent it. Equity is usually used by defendants, with one or two exceptions. Proprietary estoppel, for example, is used by people who assert that they have rights in property, and that can be used by a plaintiff. It is, outside of that, very unusual for estoppel, which is an equitable principle, to be used by a plaintiff. Equity, one of the axioms of equity is that equity is a shield, it's not a sword. So I hope that addresses the issue.
Thank you. We certainly won't be with you much longer. We are in the middle of the end.
Well, I was enjoying myself.
Could I just take you to the subtitle you have on receivers and an order for sale?
Yes, of course. I make one, and I don't know if there's a question, I can just jump into it if you...
Please go ahead.
I do make one comment, I think it's paragraph 34. Good summary of the English position, assuming, crucially, Bermuda law mirrors English law. Quite frankly, if there was an Achilles heel, it was to do with receivership. I'm well versed as to what a receiver is. I know when receivers can be appointed or employed, but I was not as well versed on the actual legal position. So I do make that little caveat there that if the Bermuda position mirrors the English position, which it principally should, then I make my conclusions. One of the things that is normally pleaded in mortgage recovery actions is for the appointment of a receiver. It is a term that you will find in every mortgage document. You will find it also in the MOD documents I refer to, the Memorandum of Deposit of Deeds, the appointment of a receiver. It's, in essence, once a bank has received judgment, and if the circumstances necessitate an order for possession, and the object of the exercise is to sell the property, or at least try to recover monies that are owing under the mortgage, then the appointment of receivers, a receiver is appointed. Now, receivers have a duty to act in the best interests of the mortgagee. And their utility from the bank's point of view is that banks are in the business of banking, and they don't want to be or aren't necessarily desirous of being involved as, call it what it is, as real estate agents. If the property is going to be sold, they hire someone else to do it. Now, the part about hiring receivers that
Or accountants.
or accountants that lends to the perception that there is a degree of unfairness is not only the fact that receivers don't work for free, neither do accountants. It's the fact that some entity, that the person who finds themselves as a defendant or the original borrower has now some entity that's employed by the bank to, in essence, just sell their property. And there is usually, and this isn't meant to be a criticism per se of accountants and receivers, but the banks, when you go in and you sit down and you're getting your mortgage, there is a certain amount of bedside manner. I'll use that because if anyone knows me, know that I have some medical practitioners in my family. So there's a certain degree of bedside manner that's employed when the banks are going through this exercise. There is not that degree of intimacy, let's use that word, that exists between accountants and receivers. So you have this entity that you don't know at a distance, basically selling your property for without your permission or consent, which also adds to it. Now, I do talk about the duty. The borrowers are protected by the fact that receivers will be under a general duty to act in good faith and to exercise their powers for proper purposes, and that's in paragraph 35. But it still doesn't lend itself to remedying the feelings of unease, of isolation, and perhaps unfairness that mortgagers, that persons that find themselves in that position, defendants or the original borrowers find themselves in. Now, having said that, I think that it is a normal, well, I think that it's definitely a normal byproduct of the whole process that receivers are appointed. Again, the banks have scores of other things to do besides try to market and sell and manage the property, particularly for those properties that don't sell right away. And anyone that's been involved in a real estate transaction recently knows that sometimes, a lot of times, these things don't happen overnight. If their property is occupied and it's rented, it's to collect the rents, to make sure that the bills are being paid, and those bills would include land tax and any other maintenance of the property, upkeep. And that's also, in fairness, I should have mentioned that earlier, one of the other things that is initially not particularized, usually when the originating summons or writ is filed, but the numbers sometimes exponentially change between the time that the writ's filed and the time that a property is sold. And that is, there are some occasions where the bank, quite frankly, repossesses properties that are in poor condition. If you can envision the circumstances of a person that's had the inability to service their mortgage over an extended period of time, you know, that could be anything, 6 months, a year, even longer. There's some scenarios that are, quite frankly, hard to believe the length of time that the person has been in default. But in any event, if you appreciate that the inability to make those payments, you can also appreciate that there are probably areas of that property that have fallen into disrepair, just quite simply for the lack of money. And what the banks will do I think on most occasions, because it's just necessary, is that they will effect certain renovations to the property just so that they become more marketable. If a property hasn't been painted for 5 or 6 years, you know, one of the first things you do before you try and sell it is you lick some paint on it, as we say, and you make sure the roof's done. All those things cost money. And you will find scenarios that the original debt was X, and by the time the property is sold, notwithstanding the lack of monthly payments, which on some occasions do stop, but the amount being owed is why, because renovations have been effected so that the property can be sold or make it more marketable, and so that it can obtain more of a beneficial price or a higher price at sale. So,
Mr. Swann, to tag on to your last point, and using the principle, my own I create, of the bank utilizing last resort, I call it, whether it is to appoint a receiver, whether it is to whatever proceedings are initiated to recover what has been owed to them. There is this view, perception, that especially in Bermuda, financial institutions and banks, they don't utilize the last resort methodology of going through a process of default, letters demanding payment, proceedings. There's a view that there is this animus, there is this difference between the borrower and the banker, and demands are made for, or mortgages are called in, properties are taken away. Can you, based on your experience, comment on that matter?
I think that...
And we're live.
Sorry?
And we're live.
I'm sorry, may I be excused? I believe that we should be cognizant, and in fact, I think it should go part and parcel with this inquiry, in that this inquiry is mandated to deal with historical land grabs and historical issues. If we talk about the historical relationship that banks have had with the Bermuda population, it should be, it really should be noted that not only are banks, but you can go back to the 60s and probably 70s from, and I'll be quite clear, in the 70s I wasn't very concerned with banks, so I think I was more...
Nor was I.
But from the things, the experiences I've had, and from various people that I have spoken to, you know, banks weren't always open to everybody. And I have great friends in the Portuguese community who will happily tell me that back in the day, as they will refer to it, that people of Portuguese descent had very much difficult experiences with banks, and banks wouldn't loan them money. The same argument has applied to many black citizens in Bermuda. And so historically there was the practice, and at least the perception of the practice, that banks were institutions that were used by wealthy, primarily white landowners, or were not used as much by blacks in the Portuguese community, for the sake of the argument. Those times we have evolved from those times. And I think that what necessarily took place is that the banks here were always local banks. And I think I can quite happily remember scenarios that I think some of the panel members will know that existed. If you wanted a loan in the 80s and 90s, you could basically call the bank, and you knew the loan officers. It's such and such calling. I'd like a loan. You could have approval over the phone, and then the same documents in terms of mortgages and further charges would be drafted. Another vernacular, the brakes were put on that around the late 80s, early 90s. And then since then, we've had a series of overseas owners and interests which have been involved in local banks. I am not criticizing the fact that there are overseas interests involved in local banks, but these are people that were not born and raised here, who understand the
Sure.
ethos, use the legal term, the res gestae of life in Bermuda. We have a lot of endemic situations that are endemic. We have differences in banking as to how we do things. I touched a while ago on, I think I use a vernacular, everybody knows everybody. There was a personal relationship with your bank. You knew, if you went in to see a teller, you knew who they were, they knew your name, they probably knew down to the shilling originally, then the pence, and move into the 70s, the dollars and cents of what you came in every week and deposited in terms of your paycheck. There was an intimacy with the relationship with the banks. That has been lost to a large extent with international banks being here. And why do I say all this? I say, again, it's not a criticism of what the banks have done for their own bottom lines.
It's an observation.
It's an observation. But what has necessarily happened is that because there is now a distance in that relationship that people had with their particular bankers, it provides an environment where when things go wrong, in terms of what we're talking about, people not paying the mortgage, different attitudes and beliefs, quite frankly, fester. And I think that because there are practices and now requirements that the banks must now adhere to or employ, which weren't there historically, or aren't necessarily supportive or tied in with an intimate relationship with your clients, then there is necessarily an animus that develops towards the bank. I mean, opening up a bank account nowadays, for reasons that I've mentioned earlier, for ATF and AML, is not the simple task it used to be. You used to be able to walk in with your driver's license. Not a lot of people had passports because you could travel on your driver's license, but you could walk in with a driver's license and, $100 or $50, you open up a bank account. You leave 10 or 15 minutes later with your bank book. Nowadays, opening up a bank account for the reasons I've mentioned and other reasons is an onerous task.
Thresholds involved.
Precisely, and it does not help, again, with the relationship. The Bermuda's bank or community banking or things of that nature are things of the past. The closest, and I think that I don't want to soapbox it for too long, but what you see nowadays, which you may have seen in the past to some extent, but you see more of a significance of it nowadays. For example, the social function that the banks provided has been replaced, I think, to a large extent with banks sponsoring large sports events. You have a particular bank that sponsors Cup Match. You have banks that sponsor various other sporting activities outside of cricket, football, and various marathons and the like. You have more of scholarships and bursaries and things like that, which I believe, this is just my view, is an expression by the banks of their social involvement. And it's still at a distance from what it used to be. And I think the complete answer to the question is based on the history and all of those sorts of circumstances. It necessarily provides a wonderful petri dish where that virus or fungus or whatever you want to call it of dislike and distrust and animosity and everything else has open opportunity to grow. And in some respects, I think that the banks get a bad rap when it comes to this, because now directly to your question or your comments about the letters before action and demand notices and everything else. I have not in recent memory, or let's put it, I've not in memory come across something personally, meaning across my desk, where a person has been in default for 3 months, and the bank has instantly said, I'm foreclosing. I have heard stories of various individuals who have had properties foreclosed. In fact, I know the individuals who've had properties foreclosed on and have argued vehemently that there were political motivations behind it, because what was waited on was for any slip in terms of the payments, and the banks being back in the day politically connected to the government and whatnot would pull the plug. I've heard more than one story in that regard, but those sorts of scenarios don't present themselves today, but they still foster these feelings because those people are still very much alive, and they are still very much people that will recount those stories to their children and grandchildren and us as a whole. But I think that in most instances, and I said this earlier, the bank does not want people's property. They really don't. They want people's money. So it's in their best interest to either try to resolve the situations, or quite frankly, they're not ones, to my experience, to pull the plug immediately, because quite frankly, the longer it takes, at the end of the day, whether this is by design or not, but at the end of the day, the reality is that it's more money that the transaction will generally, the dispute, I'll put it that way, will generally funnel in their direction.
Mr. Swann, thank you. Before the umpire calls bad light, I've asked the wicketkeeper to come up to the stumps, and I'm just going to change my mode of delivery. There is this view as it relates to not just generally interference, the perception or actual interference, but there's a view by some borrowers, especially in the Bermudian context, that even though it is acknowledged, as you have eloquently and with much erudition indicated, that persons are indebted, persons acknowledge that they're indebted, when a financial institution or a bank decides to call in the mortgage, I'm not speaking about the example you gave, which is quite apt in terms of alluding to political motives or alluding to some other personal reason to call in a mortgage. But there is a view that the mere exercise by the bank of the obligation under contract to call in a mortgage, it is a land grab. It is stealing. It is by some means taken unlawfully. So my question, which is obviously, I am bowling now from 17 years and not 22. And it is very near to a beamer. And I am certainly bending my elbow from 17 yards like a baseball pitcher.
Miralithrin's action was approved.
No. He was walking in. I'm running in from 17 and I'm flinging it at you. The question is just to have some understanding of, I've heard you speak, as I said, and you mentioned economic thought on the one hand, but on the other, what appears to be the sentiment is that if a bank exercising a legal right seeks to call in a loan, that action within itself is the financial institution stealing, that they are taking something which they don't have a right to take. Can you comment on that? I hope I have.
Well, I will take us back somewhat. And I remember, back when the earth was hot, when I was in law school, mortgages came up in terms of contractual law. And I remember having a particular professor discussing mortgages and making the comment that in days gone by, a mortgagor, a bank, could, in essence, foreclose on your property before the ink was even dry on the actual mortgage. The simple, and maybe I'm being a bit liberal with foreclose. The fact that a mortgage is a conveyance in title to the property in exchange for money means what it means. The bank owns that property until you pay off the debt. If you don't pay off the debt, it's not illegal for the bank to sell that property to recoup the monies and interest according to the contract that have been borrowed. So I would not support the comment that it's a land grab, because remember, it's not just, well, it's probably a bad analogy, but it's not just banks. Individuals themselves loan people money under mortgages. There are personal mortgages that are out there. There's a lot of them. And I would find it a difficult argument to accept that on the one hand, banks are evil, like the devil, and can foreclose on your property, and that's a horrible, awful thing. But an individual who has seen an investment opportunity and helped, call it what it is, helped his neighbor by loaning money so that he could buy a lot to build his house, whatever the case may be, and secured that borrowing by way of mortgage, and then in default wanted his money back, I don't think any of us would have an objection to him saying, well, hold up, in order for you to get your money back, the only way to get your money back is to sell that land. I don't think we would sit here and say, well, that's a horrible, evil, nasty thing. I think the context of the two different transactions involve different things. What has allows us to accept the individual doing it openly or with more open arms than we would the bank is that the individual doesn't charge all the other fees and charges and everything else that goes along with the banking experience. And again, contractually, the bank is allowed to exact, I'll call that, their give unto Caesar what is Caesar's. If contractually they're allowed to add to expect the repayment of the principal and interest at whatever the rate is, and the person has agreed to it, then that it is what it is. And if there is the need to sell the property to recoup it, I don't necessarily believe that's a land grab. No more than I would believe that an individual who, let's just even forget the mortgage for the time being, let's just say that they loan money on the strength of a promissory note, and they're forced to issue proceedings, and they secure a judgment in the Supreme Court or the Magistrates Court for the sake of the argument if the amount's under $25,000. And in order to enforce the payment of that, because the person involved, and let's create the scenario where they weren't paying the amount anyway, but they can't afford to pay the cash, but they have a property, that person can issue what's known as a writ of execution and have that property levied upon with a view to having that property sold to satisfy the debt. Now, the difference or the extra amount that property is worth, extra amount above what is owed to the person with the judgment, of course will be paid to the judgment debtor or the person that owes the money. So they will get the balance of that. And I don't think that that's necessarily, that wouldn't, to my mind, that wouldn't be a land grab. So I do think that, I don't accept that characterization in the circumstances where a bank properly enforces a mortgage that is in default, and the result of that is that the mortgaged property is sold. I would accept that if there are circumstances in which that whole relationship is dubious or is, call it is illegal, then no, I don't accept that at all. But I don't think in today's society with the amount of checks and balances that are employed, not only by our practices, our laws, by the fact that we have an overriding, all-encompassing degree of supervision. And by that I mean that social media, big brother is social media. Social media is always watching. And I would find it strange that acts of illegal acts or acts that are completely improper, which could in the past be kept relatively quiet in terms of only exposure and perhaps some media and the like, which nowadays would be all over. I don't want to name any particular social media platform, but there are several of them. You would find those widely known by people not only in Bermuda, worldwide. If there are practices that are being employed here by banks that are not not proper or dishonest or whatnot, based on what I've just said, for the sake of the argument, banks here that have overseas components, those overseas components would be made readily aware of that, I think, from one method or another. So I don't, historically, I think that there may have been glaring examples of very bad behavior, which I think is part, or maybe part of what this commission might look at and investigate improperly. So, but in terms of where we are now, I think that even if they would present themselves in a modern context, it would probably be something that would be readily identifiable and something that I think in the best interests of not only maintaining their customer base, but good customer relations, banks would probably do everything they could to address. And they'd probably want to address it before, as I've just mentioned, social media gets a hold of it and things like that. So I don't think that land grabs is the way I would characterize it. And I think that if it does occur, it's probably few and far between now.
Thank you, Mr. Swann. So, Chairman, I'm going to at this time retire, not hurt, but I'm going to retire at this time, and I have no further questions of this witness.
Yes,
I'd like to thank him for his
Counsel,
erudition.
I intend to bring on a couple of new burlers, and my commissioners, starting with Mrs. Ford, wishes to ask a question.
Of course.
I have, thank you, Chairman. Good afternoon, Mr. Swann.
And good afternoon, Ms. Ford.
I'm sure you're aware that I have experience both in real estate and banking.
I am, yes.
Great. I will start with the question based on your last response with regard to Counsel's question with regard to banks also or have been known to be in this land grabs. And so your company does conveys documents as well, is that correct?
Yes.
So if one is looking at, I'm going to name two different types of conveyances. The one where the person is purchasing a property from another. The transfer of property first goes from the owner or the vendor of that property to the purchaser.
Yes.
And then if that purchaser so happens to need financing from a financial institution, i.e. most times it's a bank, the documentation then will indicate it's then conveyed to both the bank and the new owner of the property?
No.
It used to be?
No. A conveyance is a conveyance. It is a transfer of title in the property from one person to another.
Yes.
Or sometimes from the same person to others.
Yes.
A mortgage is a conveyance of title in that property to the bank.
Yeah, I'm sorry. I should have used mortgage. So when the mortgage document is drawn
Yes.
from the person who needs financing from the bank,
Yes.
i.e. that new homeowner or whatever, how is that documentation drawn? The mortgage document, does it go from the borrower, which would be the mortgagee, the mortgagor, to both the mortgage company and the client and the purchaser, or is just to that bank, for instance?
Oh, it's to that bank. what classically, what happens in the...
But doesn't it use the word "and"? I've seen documentation where it mentions both the borrower's name and the financial institution's name, like "and."
My experience since I have been doing this is that the mortgage is in the name of the bank or the lending institution or the individual, as the case may be, and as one party, and the separate party is the person that has borrowed the money. It would be contractually awkward, embarrassing is actually the legal term, if you borrowed money from yourself for the sake of the argument and someone else, and it makes a mess of it. Classically, what happens is that the person buying the property has the conveyance document drafted and the mortgage document drafted, and they're executed at the same time. And the way we like to explain it to clients is that you signed your conveyance, and 22 seconds later, you've owned the property for the amount of time it takes for you to sign the mortgage, because the instant you sign that property is not yours, it's the bank's. Now, you are entitled to what's known as the equity of redemption, to have that property transferred back to you after the mortgage is repaid.
Yes.
But that property is not yours and the mortgages and the bank's. That property belongs to the bank.
Okay, so in the case where that same property now is liquidated under the terms of the mortgage, and one goes to a real estate company, of course, to have the property sold, who signs off on the sale and purchase agreement?
It depends. In all fairness, if the property has not reached an advanced stage of litigation, it's not unusual, particularly if a purchaser is readily available and the like, for the bank to say, okay, well, you know what, you go ahead and sign off on the property, because the bank hasn't foreclosed yet. And what happens is, during the actual closing, the mortgage monies, the new monies to purchase the property will come in. The mortgage on the property is paid off. There is a reconveyance of the property to the person selling it. The person selling it transfers title to the person buying it. Now, if the bank has, second part.
No, I understand. You don't have to explain it. For the rest, you can. If you want to explain it, I understand it.
If the bank has foreclosed and taken possession of the property, they can sell the property as mortgagee in possession. They don't need the signature of the, I'll use it this way for simplicity, the former owner. Or the person that had entered into the mortgage relationship. They don't need their signature because they can sell as mortgagee in possession. Now, if they're doing that, that occurs when either there is a court order to the effect that they have possession of the property, or by agreement of the person that had entered into the mortgage arrangement in the first place.
Okay, so in that circumstance, would you say that the person did it under duress? Because who really wants to sign off selling their own property?
In the circumstance of
where the owner has to
agrees with the bank to sell the property,
is required to sign that sale and purchase agreement. It's almost like a form of duress. The circumstances where I disagree. The circumstances where the owner of the property sells the property are such that they're selling it so they can pay off the mortgage. If they don't sell it, then it's quite simple. The bank will, if that's the intention, will follow through with proceedings, have an order for possession, and sell it themselves. If the bank asks a person, do you agree to sell the property, and they say no, then the die is cast. They go to court. If the person, and so therefore the scenario where the person does not want to sell the property, you can't have it both ways. If you don't want to sell the property, make your mortgage payment. If you're not making your mortgage payment and the only remedy is to sell the property to recover the mortgage funds, if you don't agree to it, the bank goes to court. If you do agree to it, there's no objection. And I wouldn't say that it's a matter of duress. It's a matter of your own sort of necessity. I know what you're sort of getting at, but I don't see in my practice many scenarios where the person is forced to do that. And I use that word on purpose. They either elect to do it, or if they don't, the bank signs it themselves. Okay. So in the case of where one, and you talked about it like in the prior to the late 80s, banks did what was called asset lending, not only locally but globally. And it was once that recession came into play they put policy or procedures in place where they then looked at one's ability to pay versus what we called asset lending. So in the case of the asset lending, it didn't really determine, of course, one's ability to pay. They said, okay, this is the asset, as you indicated, I know you, this is your asset, fine, I give you the loan.
Okay.
So in those circumstances where there were, for instance, not a legal mortgage drawn, but a memorandum of deposit of deeds, and one defaulted in payment, what was that process? Would they have to obtain judgment first before they liquidate the asset?
Because a memorandum of deposit of deeds is not a conveyance of title in the property, yes, you have a lien on the property by registering the equitable charge. There's a register of equitable charges at the old Registrar General's office. They now do it quite differently with the new Land Title Registry office. But in any event, you would have the amount registered. You would still have to, or you would have to, unless there was consent, issue proceedings to secure a judgment on the amount that you said was owing.
Right.
And also an order of sale, or you'd issue a writ of execution, and which you wouldn't have to do from the levy point of view, but the second part of that process would enable the bailiffs to basically affect the sale of the property.
So it could have been where some people who were borrowing money based on this asset lending, based on the fact that they may have had a memorandum of deposit of deeds versus a legal mortgage, may not have understood the terms and conditions of the borrowing. That's a possibility.
I think the possibility exists that any person borrowing the money, whether it's by mortgage, promissory note, or memorandum of deposit of deeds, in circumstances where the relationship was very casual, might not understand or could always argue that they didn't understand the specific terms. Particularly if we go back to, I think, my submissions involving, it used to be the case that you could call the bank and say, right, I need to borrow X. And you get your approval on the phone, and then some lawyer would draft up, the documents. In scenarios where the rigidity of the process that we have now was significantly relaxed, I find it easy to conceptualize that there are people under any of the circumstances, no matter what the security is, that may not have understood exactly, may not have understood all of the intricacies of what they were involved in.
Right. And I will say too, it's based on the experience of the front end lender as to whether or not prior to today's world would have maybe explained it, may or may not have explained it to that person as to what the terms of borrowing.
That's absolutely correct. Absolutely correct.
The other thing is with regard to the monthly payment, principal, and we'll say P&I, principal and interest, which is made up of principal and interest.
Yes.
So when one is in default, and say, you have some people, yes, the bank, how it used to be, would look at liquidating the asset as a last resort, which you did mention, because the banks are not in the business of owning real estate. But knowing that down the road things are gonna not change very much, and this person may be making, whether it's regular or timely principal and interest payments, is it where in that circumstance, because you have a mortgage that's in default, where the funds or the payments they were making, was it still applied to interest and principal, or did it all, or were the payments applied to principal only? And is there something around that if one is in default, yes, and the possibility of that asset being liquidated, and they were making monthly payments, how is that a payment applied? Is it applied to principal and interest, or is it applied directly to the principal?
That's really an issue for the bank. I could sit here and theorize as to what I think they should do, but that's not the question. Each individual transaction of that nature would sort of rest on its own particular circumstances. There are, for example, there are scenarios that I am aware of where families, I'll use that quite openly, have owed the bank or particular banks tremendous amounts of money that the banks are not enforcing based on historical arrangements that they had. And I would think that payments that are being made are probably made in those circumstances on interest, if they're made at all. But the reason I'm giving this sort of a very wide open, non-specific example is that each individual transaction would not only depend on the bank involved, but the people that are on the other end of owing the bank the money, and depending on the relationship that they had. I made reference when we were talking about enforcing actions. The bank will enforce them against some people, not against others. There could be a multiplicity of different reasons for why, the Jones family is several $1 million in debt, and the banks aren't selling their property, but the Smiths family owes $250,000 and the house is gone. It really just does depend on that. So I can't really, it's too general a question. There's no specific legal principle that applies to that. And one of the things also to remember is that, as you would know, forgive me, is that you saw historically more loans that were interest only than you ever see nowadays. It used to be the case that you would go and borrow, the $100,000 and you'd pay interest on it at whatever the rate was for 5 or 6 years, and then there'd be a requirement to pay the principal. And oftentimes what happened was they'd simply roll the sort of loan over.
They were generally short-term loans, but in the case, for instance, the same the mortgage, we're talking about mortgages, and that mortgage now has to be liquidated, sold, and if one is paying the monthly payment, have been, it's going against principal and interest. Now it comes down to the sale of that property.
Depends on the terms of the mortgage.
The proceeds in that circumstance, the net sales proceeds.
Oh, the proceeds, okay.
The net sales proceeds, is it applied against the principal,
It's applied to the amount outstanding.
which could comprise of both principal and interest?
Absolutely.
So that's what I want to know as far as I want to, maybe if you can check, since you have a conveyancing company, in the case of loans that are in default, and one is making principal and interest payments, is it some law, if you could check it out, I don't know, whether those monthly payments should be applied against the principal only?
No, if your agreement is that the monthly payment is an amortized payment, it's a mixed payment, then that's what it is. Those payments that come in should be.
Yeah, but it's the interest portion is it's based on, of course, there's a spread and there is.
It's based on the term of the loan. At the beginning of the loan.
At the end of the day, the bank, as you indicated earlier, you can start off with, you can have a mortgage of $1 million. At the end of the day, you've paid back to the bank almost twice that amount, just for argument's sake. So I'm saying for that person who's already in default, if you could find out for me that if the loan proceeds, the property has been liquidated under the terms of the mortgage, are those net sales proceeds applied against the principal only? Because I believe, and I could be wrong, that maybe there is some sort of protection that the bank may have for loans that are in default. So I just need to know that.
It's applied against principal.
Yeah, because it's just like if someone, you mentioned about a cable bill or telephone bill or any kind of bill, people have been charging. I know there's been some recent laws written that if you keep charging this fee, you keep charging this fee, you keep charging the fee, well, when do you catch up? So I just need to know that question.
I'm quite happy to.
Yeah, and the
get back to
other
you
one, I'm not going to be too long. The other question I have is, which you've answered to a degree, because it used to be prior to the large international banks being here, that the local banks had shown more empathy towards people who were in difficulty. We were told that, you don't take, in other words, their milk money. You make sure you leave some funds in the account so at least they could buy groceries. Now, I understand in today's world with technology that nowadays the system automatically goes and grabs. But I know with technology too, there are processes whereby you can maybe just leave so much for that person to at least buy food for their children. That's how it used to be back in the day. And also, prior to the 1980s, there was no real formalization of a recovery department because the loan officers were expected to at least recover those or speak directly to those that fell into default.
I'm aware those are new
So
sort of
then
phenomena.
the formalization of recoveries came in the very, very late, in the early 90s. And I know that since the big banks are here, there are certain things that have changed across the board versus, for instance, back then, even when it came to real estate, the realtor or the appraiser, let's use the appraiser did not have to have those qualifications and were able to go out and appraise one's property. Whereas when the big banks came in, it was a requirement that you must have those full qualifications, which I certainly do understand. I just need to know, and I guess you've answered it, that since the big banks have come in, is it less empathy? Are they really willing to work with people? Because as my motto is, only in Bermuda, our collateral or the collateral that the bank has, if it's closed up for a long period of time, within 6 months, that collateral value is going to deteriorate. So I was just wondering if all of that could be considered, because Bermuda certainly can't afford to have homes boarded up since we're a tourist industry, that we've got to show more empathy to work with people and liquidate that asset as a very, very, very last resort. Thank you.
Thank you.
Oh, yes, we have another question from Ms. Milligan White.
Thank you. Mr. Swann,
That's good afternoon.
you've worked in the international business environment in Bermuda, I'm sure, and you're aware that best practices apply in each industry, whether you're an insurance company, a bank, a trust company, and so forth. Are you aware at all of whether the banks in Bermuda have best practices when it comes to recovering debt?
I believe that the banks use their best endeavors to ensure that delinquencies and arrears are addressed. I will honestly say that I don't know whether best endeavors is something I would look you in the eye and say that best endeavors are being practiced by all the banks. Because quite frankly, I'm not entirely sure what best endeavors might mean to, well, let's call a spade a spade. It might mean to an HSBC of this world, for the sake of the argument, which is the largest of our international banking partners that are here, as opposed to the smaller groups that are involved in the former Gibbons Company Bank and now the Bank of Butterfield. So I'm a little hesitant to say that I believe that best practices are employed. What I do, or I am prepared to say, is that in some of the scenarios that I find myself in, or have found myself involved in, for the most part, banks have, I think, sufficiently gone the extra mile to see that those persons that would necessarily be disadvantaged would not be disadvantaged. I can tell, I mean, from recollection, I have two personal stories that I was involved in that involved the banks foreclosing on properties. And both of these properties were mortgaged, and the mortgage fell into default, into arrears. And in both circumstances, they involved guarantees from senior citizens. I used the terms matriarchs and patriarchs before, and it was one of each. It was a matriarch of a family in one instance and a patriarch in the other. And in both instances, the bank indicated that whilst they had foreclosed on the property and had, in fact, taken possession of the subject property, the part of the transactions in both instances involved collateral from, basically were both homesteads in both of these situations, which were not the properties the bank foreclosed on, but supported the loan. And the loans were of such an amount that the collaterals would have to be called in and liquidated in order to satisfy the banks. And in both of those instances, it was said, and in fact in writing, that the bank would not force the elderly persons that were involved out of those properties during their lifetimes. And I thought that if that goes along to address best practices, whatever they are, I think that was a good indication that some efforts were being made to at least to understand the scenario of the transaction and not to put persons that, quite frankly, were at risk, call it what it is, out on the street. So I'm not totally prepared to delve into best practices because, quite frankly, I don't know what internationally they would involve, but I do think that some of the actions I have seen, and those were only 2 examples, have illustrated that at least there was some empathy and some sympathy for the particular situation. And these were large amounts of money. These were not in fact, I've picked on the $1 million number. Both of these were significantly north of that.
And, you know, I've been practicing law in Bermuda for more than 30 years. And it's very rare in a situation where the bank is foreclosing on someone, where you would find that the bank has offered restructuring of the debt or some other means of encouraging the debtor to commit to the problem and pay over time. And it seems to me that they're dealing with the small population. Most of them are under 65, working in various businesses in Bermuda. That they would be open to, when the bank sees that they're missing interests or they're missing payments on capital, to at that time, before it becomes a big problem, they would look at, you know, consulting, asking them to get consultants to help them to restructure the debt.
You tend to see, as you would well be aware, in fact, probably more than I, when companies, for the sake of the argument, are, when a petition is made to wind a company up, one of the, and usually in the context of what we're discussing, let's just say for debt, one of the first things that the court considers is a rescue plan before making the final order for winding up. They see if there can be some salvage. And even if, and I say the court looks at it because oftentimes the person, the company, or the people behind the company that are in the position of owing the money will see if they can salvage the company one way or the other. I tend to find that in banking relationships, there is or are negotiations that take place, usually in the first instance before matters are firmly in the court's hands. And you have, and I think as Ms. Forth has indicated, more recently, as opposed to back in the day, I'll use the vernacular, you have departments that are now set up in banks. Special assets is the HSBC department. I know that Clarion has I think it's called debt recovery, and I'm assuming Bank of Butterfield has the same. Their purpose is to address arrears by people, not only on mortgages, but they also deal with credit cards and the like, just general debts owed to the bank. And their purpose is to do what they can to resolve those matters before they end up before the courts. So I would say to you that most of the efforts, most of the earnest efforts to resolve the matters, I think, are made before it goes down the litigation route. But by no stretch of the imagination do they cease once litigation has started. And sometimes, in all fairness, it is the realization that the road's coming to an end, forgive me for putting it that way, that forces or spurs some people to take actions that they didn't take when the negotiations were pre-litigation. So I do think that efforts are made prior, and I think the evidence is that banks do have departments that do that. But I do accept that Once litigation is before the courts, there is still negotiation, but it is less of, it's definitely not the court's purview to try and see if the parties can settle on the basis of the pleadings. It is part of the overriding objective to see if the matter can be resolved. But at the stage when one party is saying I am owed X and the other party, in all fairness to most of the examples, admits that they owe X, the resolution is figuring out some way to pay X. So again, whilst the courts will happily encourage parties to resolve the matter, and negotiations do take place, I think that by that stage, sometimes you're rehashing old offers and things like that. It's not. It is not. It doesn't give rise to hope that there will be, just because litigation has been initiated, settlement. If that's a good way of putting it.
Yeah. Thank you.
I hope that addresses it.
Yeah, thank you.
Yes, we do have further questions, and I'm going to request some brevity. Mr. Estoppel, Commissioner Estoppel.
Thank you, Chair. Good afternoon, Mr. Swann.
And good afternoon, Mr. Estoppel.
I specialize in brevity. I just have a few questions with regard to the valuation process. Who does produce property evaluation?
Well, the valuers produce the valuation. I'm not trying to be flippant about it, but they produce the valuations, and it depends on the circumstance. There are instances where, for the sake of the argument, the person buying the property has in their hand a valuation done by the seller. And let's say the valuation is less than 6 months old. It may be the case, and to be fair, I saw one the other day, the bank wanted something under 3 months old, but it may be the case that they accept that valuation, meaning the bank, as long as it's been performed, as Ms. Forth has indicated, nowadays with someone that has the requisite qualifications upon which the bank will rely to accept the valuation as being accurate. So the valuation is performed by a valuer, and it would be done typically in a mortgage situation, at the behest of the bank. But it may be the case that a valuation is at hand, and if it is by a qualified person and it is within a reasonably short period of time, banks will generally accept it.
Thank you.
Now also, sorry, I should caveat that by saying it depends on the purpose of the valuation as well, because for the sake of the argument, you have valuations that are done for estate purposes, valuations that are done for sale purposes, valuations that are done for cost of renovation purposes, and they differ in the quantum of what they say the property is valued, or the cost. For example, with the renovation or repair approach, insurance companies, for example, have different forms of different requirements, valuations than banks do. So,
Okay, thank you. Next question. Is there a difference between historical valuation versus current practice? And what is the corollary between the evaluation and the actual sale price?
the actual sale price is what somebody's willing to pay for it. I'm smiling, there's no real simple way of getting around that. The difference between historic valuations and present valuations, they still use a lot of the same mechanisms. I think that because we are, nowadays you can get online, and basically the real estate agents have these wonderful programs that will tell you, they can list properties in a particular neighborhood or particular type of property that's sold at a particular price. There's more of a readily available comparison of values. So if you have a value on Middle Road, Southampton, 3-bedroom, 2-bath, you can say that, you know what, I've gone in and I think this property is valued at X. My support for that valuation will be that there was another property on Middle Road, Southampton, same sort of neighborhood, whatever, that also sold at close enough to X to justify my valuation. You didn't tend to see that with a lot of the older valuations. You'd still see a comparison, but you might have one or two. Nowadays, you tend to see 5, 6, upwards, sometimes I've seen as many as 10 on a page valuations. You tend to get that a lot with lots of land, for example. The lot is this size, it's Res 2, Res 1. So the difference is that the valuers still go out, but I think that the availability of comparable data is more readily available. Well, it's more available now than it was in the past.
Thank you. And my final question, has there ever been any attempt to assess if or how many unjust mortgage calls have been made against Bermudians. To put a finer point on it, people who are not in default.
Is there any way of ascertaining that number?
Has any study,
Study.
investigation?
Not that I'm aware of. Not that I'm aware of. I would have thought that, I'm not aware of any study or examination, but I would hazard a guess that if a person had their mortgage called unjustly, they would have issued proceedings.
I bring that to you as a question because you've alluded to what people have anecdotally said over the years.
In both of the scenarios I referred to, one involved a person that actually was in default, and the mortgage was called in short time, if what I've been told is correct. But the person was actually in default, and it was a commercial premises, and they were asked to provide collateral by way of a personal property, and did not want to do so. They wanted to explore their options. Bank wasn't having it, and called the mortgage. Now, the other one is less clear, but I do believe that there was also a default. So I'm a little...
Let me redirect you. Okay. Within the context of our remit being historical land grabs, I'm sure, any innumerable amount of families have a story, legend, where somebody's property was taken because of political affiliation, business affiliation, or any garden variety of issues. So that's what has there ever been any investigation or inquiry, I hate to use that word, that you're aware of? Or
outside of these proceedings, no. No, I'm not seriously, outside of these proceedings, no, I'm not aware of any. Again, okay. I think that you hit the nail on the head in part of the question. There have been rumors and legends and anecdotal stories and the like, which I think everyone in this room, anyone that's been in Bermuda has heard them, heard something along those lines. But no, I don't think there's ever been a study per se of that.
Thank you. Chair?
So thank you, Mr. Estoppel. Commissioner Starling would also like to put in questions.
If I could just, for 1 second, I'm trying to get the gentleman's attention right there that's standing. I wonder if you could, thanks. And I apologize. Thank you very much.
No, that's all right.
Thank you. Good afternoon, Mr. Starling.
Hi, good afternoon. I apologize in advance. Amongst my fellow commissioners, I'm the least learned on these matters. I don't even understand half their questions. So I apologize if I repeat some of their questions or if my questions are ignorant.
No, there are no bad or ignorant questions. They're just questions.
My mother used to say that, and then she said, then I was born. So I don't know. I'm going to get a message later. She's watching. I'll try to keep them short and sweet. What is predatory lending?
Predatory lending has been recently highlighted in the newspapers or in the media and whatnot, involving lending that provides the money in exchange for exorbitant repayment, either interest rates or the like. And it tends to focus, I put it in the same bucket, so to speak, as payday loans. You will, the promise is that it's a short-term loan and that you will repay it, on the next payday and the like. And in exchange for the money that you're given, again, the predatory loans are repayments that are just high repayments based on it.
So could there be cases where you have someone wanting a loan and the bank knows that they're not going to be able to pay it back, but they see the benefit of the collateral and rent that money? In other words, give them enough rope to hang themselves and then benefit from that. Hypothetically.
Hypothetically, I would think that more historically than at present times, that scenario would exist. There are, one of the safety nets, I'll call it that, and I'll say this openly that I am by no stretch of the imagination fully familiar with this, but I've had a few conversations with bankers of late. who have indicated that the BMA Bermuda Monetary Authority has particular requirements on not only the lending in terms of whether loans are secured by way of mortgage as a percentage of unsecured loans. Also, there are specific now requirements for liquidity the bank's actual cash assets in terms of monies that they have on deposits, which all flow into scenarios that it seems more unlikely than likely in today's climate, where a bank would basically pay out any large amount of money, hundreds of thousands of dollars or millions of dollars, on the hope that they would then gain property.
Can I just say something to add to that? That the payday.
For the payday loans, they're not never been popular in Bermuda, and they're usually very short term with a high interest rate.
Yes, I mean, sorry, I didn't thought thank you very
Thank
much.
you.
Yeah.
And these are terms I remember from the generational trauma of 2008, so bear with me. Would predatory mortgage servicing be similar to predatory loans?
In principle, yes.
Okay. Has there existed in Bermuda unjustified risk-based pricing where different demographics may have different interest rates attached to their loans for various reasons?
Yes. And I think that requires an explanation. Simply put, the higher risk you are will determine, in some instances, what the interest rate is. And if you are a favored or valued client, let's put it that way, if you are a person with large holdings at the bank or have a great credit history with the bank and they want to encourage your business, of course they'll offer you lower interest rates to secure that sort of business. So by no stretch of the imagination would it be accurate to say that every single person that walks into the bank to get a mortgage, for the sake of the argument, has the same interest rate. Interest rates also vary by the term of the loan and also the amount of money that you're borrowing. So it's any person walking into the bank, again, I think I'll flip it this way. It is to be expected that different people will have different interest rates at the bank depending on not only their personal circumstances or perhaps demographic, if you put it on that level, but also based on the amount of money that they earn. And then I say that the demographic also leads into the money that they earn. We're not condescending into necessarily race or ethnic background. I think the demographic encompasses wealth as well. So.
You touched on terms and conditions may not have always been known back in the day due to the casual nature of things. Would it be fair to say that not every borrower knew that the terms, the loan price were negotiable? They could have come and negotiated. They just took what the bank said at face value? In borrowing scenarios, I think it would be irresponsible to assume that a person that's borrowing money didn't realize they had to pay the money back. That's the general premise of a loan. I'll give you the money, you pay it back. I mean,
I'm saying, I think that in terms of whether the terms and conditions of that loan were set in stone or not, I think it would be eminently reasonable to assume that not everybody would understand that perhaps you could go into your lender and try to negotiate a difference in either your interest, your payment rate, the length of your loan. So I would accept that not everybody would understand that you could probably go and apply to vary your loan. Because there are, in fact, there are legal documents, there are variations of loans that get executed, and you generally don't see as many of those as you see other documents, which might lend itself to the belief that it isn't widely known. People just accept what was given to them in the first instance and just soldier through it, so to speak.
Thank you.
I didn't know if Ms. Forth had something.
Not so much in the loan, but with regard to appraisals, for everyone's knowledge, an appraisal is not an exact science. It's just an estimate of value. Just what I wanted.
And it is not unusual to have more than one valuation done. I mean, generally, you stick with one, but it is not unusual someone to say, wait a minute, I think that this property is worth more than that, you've overvalued it, and ask or request for a second valuation. It's not uncommon.
Thank you. In paragraph 12, section C, you talk about banks exercising undue influence. One thing that came to me from that was that banks, especially in Bermuda, might have a monopolistic power in terms of their close connections with law firms and politicians. I think you alluded to that elsewhere. And I was wondering, do they have power, or did they historically have power to the degree that they may have used such power to disempower borrowers seeking legal challenges to certain actions?
I would have thought that the
I'm sorry, I'm not interrupting it. I'm just wanted to put it in context. I know Commissioner Starling has asked a question, but paragraph 12C that he refers to, I think the author of the document who's about to answer, he was setting out what are some of the categories of defenses that banks claim, defenses to which
defendants
bank
claim
claims
against that.
lie. So I don't think he was saying that he said so. He was setting out examples of what persons say. I just want to put that in context.
To be clear, just the undue influence inspired me to ask that question. It was separate from what he's actually talking about there.
Well, undue influence is an area of law that involves taking advantage of a protected relationship. And strangely enough, the relationship of mother and child, parents and child is a protected relationship. One of the areas that case law has determined that is a protected relationship is actually banker and client. And because of that, undue influence involves a relationship of trust whereby you rely on the relationship, because of the relationship of trust, actions that would have taken place otherwise, other than that, having had that relationship would not have taken place, and something detrimental has happened as a result.
With respect, I mean more in the layman term of like this legal law firm won't represent me because they don't want to lose the bank's.
Well, that's a different question.
Well,
there are. I know of anecdotally. I will not mention the name, but I do know of a particular person that was involved in extension litigation with a particular bank, and there were series of law firms that were conflicted because they did work for the bank, and were a little reluctant to defend the individual for fear that they would lose the work that they get from the bank. So the answer to that, in at least this one instance, was a categorical yes. But I can see scenarios that would apply to that particular scenario going forward, because there are particularly firms that do specific works for banks, mortgages and loans and the like. It's a very lucrative business for a conveyancing practice, and you really don't want to interfere with that. If you don't have to. I think I don't have to speak necessarily generally on that. That's just business sort of one-on-one. But there are law firms that will not act because of their relationship with the bank. Yes.
Okay. I can feel the chair getting prepared to kick me under the table, so I'll wrap up with a final question. In paragraph 26, this may not be directly related to what you're saying. It's just inspired by it. You were talking about the exact quote would be, nor is the fact that the bank have treated other customers, borrowers differently, that is a matter for them. That just inspired me thinking about the Human Rights Act in 1981 prevents discrimination now, but back in the day, I believe you mentioned that there may have been discriminatory practice regarding access to capital, and I think you did touch upon it. I just wanted to clarify, did you also suggest there may have been discriminatory practices in terms of pulling mortgages and interest rates for loans and so forth?
No, I don't think that they're discriminatory. Again, if everybody in this room walked into the same bank over the period of a week and applied for applied for a loan of exactly the same amount, based on the relationship that person has with the bank, I would hazard a guess at saying that the interest rates charged would not be uniform across the board. That's one. Two, if everybody in this room walked into the bank and we did starting with counsel and said, right, go in and ask for $500,000, and went around the room and got to me and it was, well, ask for 1.2 million or at $100,000 increments, different amounts. I would guarantee that there will be different interest rates. If there are different terms of the loans, there'd be different interest rates. And so I don't, I'm not saying that it was discriminatory. I'm saying that the interest rates and the fees and charges and everything else are just necessarily different depending on the transaction. For example, when you go into a bank, I used to always find this funny because they used to have on the mortgage documents a fee called a finder's fee. And I used to joke, well, the bank went into this room and found this money that they were going to loan to you. It's now called a negotiation fee. But you'll have valued customers at the bank that in some instances the bank will waive the fee, and in some instances they won't. If you have an existing mortgage with the bank, for the sake of the argument, and you are selling the property that mortgage is attached to, but you're upgrading and you're buying another property and you're also getting another mortgage, chances are they won't charge you a finder's fee or a negotiation fee. And to me, that's not discriminatory. However, and no, not however. Also, I think it's important to note that some people are treated differently from others. This was in the context of enforcing delinquencies. It is a well-recognized principle in law that, for the sake of the argument, if people are jointly and severally liable, if 5 people sign a mortgage and the mortgage is in default, but one of those 5 has the deep pockets, you can go after that one to the exclusion of the others, or go after all of them and only enforce any order against that one and not the others. And that is just a principle at law. So the fact that the bank might sue John Smith and not Joe Thompson is really a matter for them.
And I get that for 2021, but what about 1951?
Back when the earth was really hot. I think there is enough history in this very room to recognize and understand that some people couldn't even go into the bank back then and expect realistically to be entertained on an application for a loan. I think that's just the way it was. With that in mind, I don't think it's any stretch of the imagination to follow that through by saying that certain people were treated differently from others.
Thank you. Having made my ignorance plain to everyone watching, I rest my questions for now. Thank you very much.
Yes, Counsel, I've had a request from our commissioner who's on Zoom. I want to know if Mrs. Binns wishes to have a question put to the witness.
Can you hear me? Hello?
Yes.
Yes.
Evening, yes? Yes,
Thank
Ms.
you.
Binns? Would you put your question?
One. I know that we talked about the banking practices as they are today. But are you aware of the banking practice where it was embedded in the mortgage document that the bank had the discretion to call in the mortgage of a borrower at any time?
Sorry.
Yeah, sorry, at their discretion.
I think I alluded to earlier, I think I was talking about one of my professors at law school, and at one stage, a mortgage or a bank could call the mortgage before the ink was even dry on the document. So I did allude to that. I am not able to answer the question in regards to at what stage that practice was eliminated or done away with, but in theory, my understanding is that at one point in time that did exist.
Okay, thank you. Because there was a period of time where there were it's case law, backed up by case law, where the banks would call in mortgages at their discretion and then only call in the mortgage for the amount outstanding. Are you aware of that?
Well, if you're calling a mortgage, it's the amount due under the mortgage. If, using your example, if you borrowed, $100,000 and you are outstanding, and you've made payments such that that's paid down to $90,000, that's what they're calling.
Okay.
So it is the balance of whatever's owing. If you call the mortgage, whatever is owed under that particular mortgage document that the bank is asking to be repaid. If you're, that's the answer to that question.
Okay, but, and this is leading into the next question. Because borrowers had been paying on the mortgage for however long before defaulting, it appeared that the practice of just calling in the mortgage that was outstanding was unfair. And I raised this because in a practice directive, August 8th, 2013, it was necessary for Chief Justice Ian Caverly to actually put in a practice directive about matters on conducting sales of real property in execution of judgment. And it was necessary at that time to actually state that where private sales are conducted by mortgagees in possession, regard must still, of course, be had for the duty to obtain the best possible price at the time of the sale. And the case that's quoted is Agnes versus Bank of Bermuda Limited. So I agree that back in the day, the relationship would have been different, and the banks were less inclined to be following practices other than local practices. Now they're bound by international standards. So I only raise that because there are a certain period of time where people were actually losing their property because of they defaulted for whatever reason, and the bank would only take what they owed. That falls squarely within our remit because it's a loss of property falling under a category, a catch-all category, that people were losing through banking practices, property that they owed mortgages on. Yes, it's contractual, but they were going losing not just the property, but the equity in the property. Are you aware of any cases that have come before you in your practice where that has happened?
Well, let me answer it this way. I am familiar, to be fair, I didn't remember the names, but I'm familiar with the practice direction in this context. For years, the practice was once the property was foreclosed upon and possession was obtained, and if you went the route of writs of execution and the like, and the property was being sold, it was sold at public auction. And they were, for the most part, I'm not saying that other ways of sale didn't take place, but my experience was that most of the practice was that a newspaper ad was posted, and it would announce that the sale of, number 1 Pleasant Lane, I think the address I referred to before, was being sold by auction. And necessarily what happened was that you had fire sales, forgive the expression. Instead of, if it was in the hands of a real estate agent who have every degree of motivation to get as much money as they can for the property, you would find these auctions, people would turn up and they'd pay, very little amounts on the dollar, so to speak, for the properties. Now, there was, I shouldn't say little amounts on the dollar. They would generally sell for less than what they were worth. I think that what necessarily happened over time was that reserve prices were set for the properties. Now, the reserve price would have always just been at least the amount of money that the bank or the mortgage holder was owed. I think that the courts, and rightfully so, perhaps under the direction of the former Chief Justice, Mr. Caverly, recognized that this was a problem, because it's always been a principle that even in default, once a property is sold, whatever monies were left over after the debt was paid belonged to the former owner of the property. The issue was whether the properties were being sold at fair market value, and clearly they weren't. What has transpired, I think, for the most part since then, is that, and I think anyone will notice that you don't seem to see those ads in the paper anymore for the sales. A lot of sales are being managed or conducted by what's known as private treaty. And basically what would happen is that there would be valuations of the property. The property would be foreclosed. There would be an order for sale. The property would be valued, and an application would be made to the courts for the property to be sold by private treaty. A complete application would have, for example, the sale and purchase agreement, which would set out the value of the property, the person buying it, and also annexed to the affidavit, which would be the form of presenting the evidence, would be a valuation showing what the market value of the property was. Now, it's a much better scenario than sales by auction, but it's not infallible. I mean, for the sake of the argument, if there are certain properties, and I could rely on Ms. Forth with her experience to either confirm or deny this, but there are certain properties that we all know sit on the market for a long time, an inordinate amount of time. And one has to consider the balance between settling the debt, particularly if, and I use the word if purposefully, the interest clock is still ticking, because any judgment as a matter of law attracts interest at the statutory rate. Whether the bank has, forgive the vernacular, turned off the tap, so to speak, of what's owing. So the longer that property sits on the market, arguably the less equity the person that owned it will have if the clock is still ticking. So sales by private treaty do have an obligation to also try and get the best market price for the property. But I would be mischievous if I said that they guaranteed that the property sold at fair market value. People still realize they're being sold by private treaty. They realize it's a foreclosure, and will always try their best to see, purchasers are purchasers. They'll try their best to see if they can buy it at the lowest price they can. In situations like that, what would necessarily happen is that, and we've conducted this practice on more than one occasion, we would put an ad in the paper saying that the property is being sold by private bid. So you invite anyone that's interested in the property to put a bid in on the property, and you take the highest bid, as long as that bid is above the reserve price. And that protects the former property owner from a situation where the property is sold at, amazingly sold at or at amazing undervalue. I'd also remember the danger in generalizing the terms of this sort of conversation are that we are facing now a period of time where property values have decreased. And so you have to be cognizant of what was a $1 million property 10 years ago. I think I made the submission earlier on, might be worth $750,000 now. And that's, and you can't displace its actual value now, going full circle to the question asked a few minutes ago. What's its value? It's valued at what it sells for, what a person's willing to buy it for. So you have to bear in mind that there is a balancing act between what it's actually valued at, what someone will pay for it, and put in the back of your mind actually what it was mortgaged for years ago, when I think in most scenarios meaning more than 80%, I don't know, I don't want to put a percentage on it, but more properties are worth less now, or stayed at their value, as opposed to values have come down.
30% in some cases a little more.
Oh no, I meant the percentage of properties. We would take all the properties in Bermuda. We could safely say that on average, the properties have gone down for everybody.
Yes.
Yeah. So you have to balance that, keep that in mind when determining at the point of sale after foreclosure what the actual fair market value of that property is. And this fully goes full circle back into the point that people feel that they are being treated unfairly or badly or illegally or fraudulently or by the banks, when you had a property that was worth significantly more years ago and whose value is dropped by 30%, and that 30% isn't even achieved at a sale by private treaty because that's what the market bears.
Ms. Binns, is that a satisfactory answer?
I just wanted to round it off by saying that I'm so glad that we've moved away from the complete discretion being only afforded to the bank, and that we're moving into more protection for the borrower. because I think there's a class of borrowers that didn't get the consideration that is being given to the borrowers of today. And I think they are the ones that fall within our remit because they didn't have the protections that you see now. Would you agree to that?
I think necessarily that there are borrowers historically that do not have the protections that we have now. That's a fair generalization.
Okay.
But I think it's also, I mean, there are a class of borrowers, I'm picking my words very carefully, that have enjoyed relationships with the bank. And I think that one of the areas that would, one of the scenarios that would confirm what you're saying in part, and I think it is, I think it's a situation that is unfair, and I'll just leave it on that level, is that there is a whole slew of borrowers that are bank employees that have borrowed monies by way of mortgage. And I'm not particularizing this to any bank or banks. It may or may not have happened to any or all of them or some of them, where the employee discounts were applicable. And in some circumstances, those employee discounts almost overnight were removed. And the effect of that was that very low interest rates on mortgages exponentially increased for those people that were still employees of those particular institutions. Now, if you took advantage of a lower rate and ceased to be an employee, I understand that. Then you should not perhaps be able to enjoy the benefits that employees enjoy. But I do know of scenarios where there have been complaints about that particular occurrence taking place on not necessarily a small scale. That would, to my mind, be a class of people that have been perhaps not treated as well as they could have.
Okay, so there are historical cases, and then there are present day cases. So at the end of the day, we need to look at the borrower and seeing how we can protect them when it comes to borrowing. And thank you for your explanation. I really appreciate your clearing up, some of the issues that I did have. It was very instructive in terms of the lending process.
My pleasure. I will say that in reference to my last example, this is, I've said what I've said in the absence of any explanation that's been given by any of the banks in regards to why these sorts of things took place, because it may be the case that, going again full circle, a regulatory authority or some other body may have thought that, for example, these preferential rates given to particular people at the bank were something that wasn't acceptable in terms of perhaps bias or treating people favorably, as some people favorably as opposed to others. So I don't know. So I've made the statement, but I would openly accept that there may be a very reasonable, or maybe an explanation that for that should be set out, so that there isn't a perception that the behavior was necessarily very bad behavior. Let's put it that way.
Right. And I just wanted to close out by saying that the proposed legislative changes in regards to consumer protection when it comes to mortgages or any other sort of protection is timely. So thank you very much.
Pleasure. Thank you.
All right. Thank you very much, Commissioner Binns. And I want at this time to thank Mr. Christopher Swann, barrister, for your very relate information. Certainly it'll carry this commission forward in our deliberations of matters that you've described, especially banking matters. And I just want to thank you on behalf of the Commission one more time. And I hand over to you, Consul.
And thank you very
Close
much, Mr. Chairman. It's been a pleasure to have been invited to participate, and I am always happy to assist if required.
Thank you.
We take the adjournment now.
Consul, you're ready to adjourn? No
I am.
questions?
I've had my fill.
Yes.
It's not T20. This is a test match.
Yeah. This Commission of Inquiry is now adjourned for the weekend, and we'll
Until
resume
Monday.
next week at a time that will be announced, and we'll now adjourn.